at that text message? Answer, the day I sent it, November 20th, 2018. Question, so you haven't looked at the message since? Answer, no. Question, when you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question, or excuse me, answer, it's an iMessage and it changed from delivered to read. Question, okay, so do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer, no, I didn't look at it for 7 years. Question, now the fact that it said read, did that stand out to you? Answer, yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Caitlin Caneiro. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was when you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense, the first time the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this. I've reviewed the state's brief, which I received somewhere around 8 o'clock last night. It was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone, to include the actual text message that was marked red and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion, which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the state, which it never was, and because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response and the defense's response, for the first time, defense counsel admits that she had an actual screenshot of the phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour, and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence about that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble. But, of course, this was dealing with when Vogt collected the DNA samples in 2020, not in 2018. Second, the state argues that it demonstrates, that this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out, I want to go back for a minute to the text message. There was one thing I did want to add to that. In the submission, no, I don't need to go back. In the submission, it also points out that that when Katie learns of the location in February of 2019, that she sees that the location was at Corey's house, there's a footnote that the defense counsel talks about, which says, it should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it either via text or phone once she saw it that he had the location, and asked him why he had taken Jesse's iPad. That is the first time and only time that the court is aware of that either there is a documentation in a phone of either a text message or a phone call in Caitlin Caneiro's phone that could corroborate or provide information that could be investigated as it relates to the issue of whether that occurred or not. That either text message or phone call was not turned over to the state, and if it was turned over, they can tell me when they start to argue. I should point out that the defense is, in saying everything that I've summarized so far, the defense is saying that they are not suggesting that the iPad was taken at the time of the murders, as it was clearly depicted during the testimony of the forensics detective when he went through the evidence found in the kitchen, where there was an iPad located there. The iPad, I guess, based upon what defense counsel is saying, is that the iPad that's located in the kitchen is actually Jesse's iPad. I don't know if that was clear during the testimony at all, that somebody said specifically that they knew that it was Jesse's iPad, but that also is something that's being argued. But what the defense is saying, that they were trying to be careful to make clear to the jury that Katie saw the location in February 2019, a few months later, so not to be misleading. However, there was no context to this as to when, at that point in time, how long that the location was at Corey Caneiro's house for this iPad. It truly was unclear because we didn't get that far based upon where we were. Defense counsel further argues that the state had full access to Susan, Katie, and Marissa, that the state had the ability to interview them just as much as the defense did. However, what's interesting to note about that is that it's clear from this submission, and it's noted specifically as a footnote, number 3 on page 4 of the defense's submission, that the defense was aware that the state was making efforts to speak with Susan and to Katie and Marissa close to the time of trial to make a decision on whether probably if they were going to call them or not. However, that none of them were willing to speak. So the state did not really have access to them. So when it comes to the defense putting in their submission that for the weeks during the course of the beginning of this trial that they were not sure if the state was going to call the either Susan, Katie, or Marissa, the court has some level of concern of that statement based upon the fact if the state had no idea what these individuals were going to say, why would they call a witness that they have no idea what's going to come out of their mouths other than a statement that was given 7 years ago, but now they're unwilling to speak to the prosecutors. So I'll leave that for another day, or for the state to deal with if there's something that should be added. I'll point out that while the state did have Susan, Katie, and Marissa are all on their witness list, the witness list is a list of people that may be called. It's not every. It's more people that are ever involved in a case. The witness list is used not just for the potential witnesses, but it's also for the jury to know, to be read each individual's name, so that if one of the jurors happens to know one of these individuals that may not be called as a witness, it's still important for the court to question those particular jurors as it relates to that issue, on whether that if they knew that person, even if they're not being called, would that have impact their ability to be fair and impartial. So the fact that the Susan, Katie, and Marissa were on the state's witness list is of no moment to this court as it relates to them being there, and as to whether that there was an obligation here to turn over this type of evidence. I also want to point out that counsel brings up the fact that, well, this trial is moving exceedingly fast. I just want to say that I've disagreed with that from the door. I gave the March 20th date because everybody indicated that that's how long the trial would be. It was never what the court thought how long this trial was going to take. As the trial went on, it was clear that this case was moving quickly. As early as the first week, it was clear that this case was not going to take as long as what was being said of March 20th. So I don't find that the movement of the case in an expeditious way was any surprise to any of the parties as we move forward as to when the prep of Katie was done, or how ultimately we come to the conclusion of where we are today. So defense also talks about state versus tier, and I'll get into that when I give my ultimate decision. And lastly, the state says that that it doesn't believe that it violated any reciprocal discovery, but if it did, that it should be a brief continuance instead of a violation that bars the actual testimony. And there was 2 exhibits that were supplied with the defense's submission, which includes, again, a photograph. In Exhibit A was a photograph of the kitchen area where the defense is indicating that Jesse's iPad was located on there. And then, again, that's what the defense is saying. And then second was the actual screenshot that was never turned over. I summarize what people have said so that we don't need to reiterate the actual arguments. However, considering that the state submitted their submission before the defense, I don't know if there was something else that they wanted to respond to, but I'm going to allow both sides to create their record before the court makes its ultimate determination. I'll start with the state.
Thank you, Judge. Now, I just want to start off by saying that I think that the court's summary with respect to the issue that came up yesterday and the court's summary of what was stated in the briefs is spot on. I mean, I think that the court essentially hit every point that the state would have argued. Obviously, the state and the defense, in any case, have different discovery obligations. We're all aware of that. But that does not mean that when you are in possession of a document that you decide not to turn over because you weren't going to use, it doesn't mean that it's not a discovery violation. I mean, they did use it. They didn't use the physical document, but they used the information in there. That's where the state has a problem. I don't want to get on my high horse, Judge. I'm not going to belabor the fact because the court's spot on in its insight with respect to everything that it said this morning. But as someone who's been with the prosecutor's office for almost 23 years, especially in the last few years, I've had to sit back on cases that were not mine, some of which I then had to get involved in, where the prosecutor's office was being accused ad nauseum of these heinous discovery violations, when in effect, a lot of times it was essentially some sort of minor oversight, clerical error, but yet in the press, the state and the prosecutor's office was looking like the demon, the villain. I'd submit to this court that over the course of the last 7 years, this office, myself, Ms. Wallace, our paralegal team, our clerical staff, have done everything possible to make arrangements to provide discovery to the defense. I've been personally, not by these attorneys, personally had my credibility tarnished, or attempted to be tarnished, by a prior attorney for Mr. Caneiro, wherein I had to write a very scathing letter pointing out that in fact we did not have something at a certain point that we were accused of having and not providing. We provided discovery. It's been gone over ad nauseum by Your Honor, by Judge Oxley, every status conference. Is there any other discovery? We've done everything we can. I'm not trying to make this more than it is, but I think based upon the submission that we've received from the defense, certain things are clear with respect to what they had, and I would submit to the court, as I stated, that I don't believe that the New Jersey Supreme Court intended for their opinion to mean that, hey, let's not document it because then we don't have to turn it over. I don't believe that's consistent with the language about encouraging practitioners to participate in cooperative discovery, etc. It's pretty clear what we have here. It's a clear situation. The court's insight is spot on with respect to the Susan and Katie and Marissa. You know, a lot of what Ms. Mastalone said is accurate. We did make attempts, and just because we didn't, Detective Petruzzello or Detective Weisbrot didn't document every effort over the course of the last 7 years to make contact with the family, doesn't mean it didn't happen. They know it happened. We tried our best to not harass them, certainly, but we had made efforts. Ultimately, it culminated with, we were supposed to meet with them on the Friday before the first trial date in September, and it was canceled because we were here arguing whether or not Mr. Caneiro would be released. Then, prior to trial, we made efforts again. I did speak to Ms. Pastalone about it. She said that she was in contact with them and would tell them to give us a call. Ultimately, Ms. Caneiro called Ms. Wallace back and indicated that she didn't feel comfortable talking to us. So, they were on our witness list, yes, but as the court noted, properly noted, that we can't put witnesses on the stand when we don't know what they're going to say, i.e. exactly what happened yesterday. This is not information that was provided to us. It was not known to us. We would have objected to the first part of the testimony yesterday had we known it was coming out, which we did not, obviously. And then, obviously, it became clear with respect to the iPad location and that clarification that she saw it in February of 2019 does nothing to clarify to this jury when that iPad was taken by Corey Caneiro or his wife or whomever who actually had control of the property after the scene was released by virtue of the executive status. That being said, Judge, I'm not going to belabor this anymore. It's clear exactly what we have here. It was a document, it was not provided, and there was other information that was
Let me ask you this question. If the court felt compelled that it had to allow some of this information, even if I do find a discovery violation, I just want to know the state's position as it relates to a need for time to investigate some of this information that you're literally learning five and a half weeks into a trial.
Judge, the testimony yesterday that she looked at, all of a sudden she looked at a text message and said read without the document, I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
Yeah, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Because I worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know. No time is going to allow me to figure out how that became read. It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Wallace would disagree with me, that time is going to do anything at this point in time. It's not going to allow me. I know I can find out when Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message after the fact. It's just that document is just clearly inadmissible. Whether the court ultimately tells the jury to disregard the testimony about it, that would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Pastalone, would you agree with me that the document, the screenshot that you had, was an electronically stored document within Katie's phone?
The document that I had, Judge, was simply a screenshot of what she observed in live time.
But my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is or in your opinion, or it's not. So
In my opinion, it is electronically stored in her phone, yes. Is it electronically stored as far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before, so you did have access to, not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it. But I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So, yeah, you did have time. You absolutely had time to turn it over, and it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. Tier says one thing, it does. But Tier does not mention, and it does not deal with the fact, when something, it's not created by you, no one's asking you to create anything in this case, it already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This, in this court's opinion, aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it, and you didn't turn it over. So if your answer is anything other than when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all I can say.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I can say.
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance, so the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate to refresh her recollection would have been what you had in your possession, which was the screenshot, which included underneath the word read, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record, as you just did, but the reality is simply this. You were given the opportunity, under these circumstances, to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions, as I did before Katie Caneiro's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There's a 25-page ex parte letter that pertains to Corey Caneiro. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post behavior by Corey and/or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, that's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes, exactly.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020. A contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house and getting stuff out?
Judge, could I just...
It might have been a mix between Petrozello and Detective Vogt.
I think there
Who
was...
specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no...
You know what I'm asking you. It's not. We're not talking about AIG. We're talking about the fact, what's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
I don't... I mean, at this point in time, I don't specifically. I don't have a recollection of exactly where that came in the trial.
Okay.
I know I didn't... I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure. I know it's a fact we knew. I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case, but number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes can I find it. So I'm not saying that I'm right. That's why I'm asking these questions, because I don't think it exists and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony. And really, I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible, piece of information, I don't know. It was in the discovery, and they don't have the iPad. So, from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutor, is there something you want to say before?
Judge, I just want to clarify something that really is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire. That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who, went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds at school. So that's just to close the record in that regard.
I'll be back. Let's not bring up the jurors yet.
All rise, court is back in session.
Be seated. There was an issue before the court yesterday that the court summarized earlier in oral argument, but did not render a decision on the admissibility of the evidence when it was brought up at sidebar. Instead, the court expressed concern that the information, having not been previously disclosed to the state, potentially constituted a discovery violation. The court directed both parties to submit written memorandum addressing both the admissibility of the evidence and the discovery issue. After reviewing now the written submissions from the state and from the defense, and also listening to arguments this morning and a review of the applicable case law, the court will render its decision now. First, I want to start with the premise under State versus Knight 256 NJ 404 2024, quoting State versus Williams 80 New Jersey 472, 478 1979. Quote, the thrust behind the reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. With that being said, in looking at our New Jersey court rule 3:13-3B2B requires the defendant to provide to the state, quote, any relevant books, papers, documents, electronically stored information, and any other data or data compilations stored in any medium from or through which information can be obtained. The phrase electronically stored information is broad and encompassing a wide range of digital evidence, but it includes and is not limited to text messages, emails, photos, videos, location data, metadata, and other information stored in electronic form. Rule 3:13-3F provides remedies when a party fails to comply with discovery obligations. The rule states, quote, if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with this rule, the court may order the party to provide the discovery, grant a continuance or delay during the trial, prohibit the party from introducing in evidence or material not disclosed, or enter such other order as it's deemed appropriate, end quote. Critically, Rule 3:13-3F also imposes a, quote, continuing duty to provide discovery, end quote. In other words, discovery obligations do not end when initial discovery exchanges are completed. If a party learns of additional discoverable material at any point during the proceedings, including during trial, the party has an immediate obligation to disclose that material to the opposing party. In this case, the defense has relied on State versus Tier, where the Supreme Court held that Rule 3:13-3 does not require a defendant to generate a written witness statement where none exists. That's Tier at 228 NJ at 568. Tier protects attorney work product, specifically written summaries or notes that defense counsel creates during the investigation. The court in Tier emphasized that that compelling defense to create statements would invade the attorney-client relationship, reveal defense strategy and theory, and violate the defendant's Sixth Amendment right to counsel. The court did not address and specifically did not decide what obligation a defendant has with respect to independently created physical or electronic evidence that exists separate and apart from any work product created by defense counsel. In Knight, the Supreme Court addressed a question Tier did not resolve. What happens when independently created physical evidence exists and defense has access to it? There, the court held that an affidavit not created by defense counsel must be disclosed under Rule 3:13-3B2B. The court indicated, quote, "The affidavit is physical evidence of a crime. It's not the product of the defense investigation or attorney work product. Rather, the affidavit is a relevant writing, potentially in defense counsel's possession, pursuant to Rule 3:13-3B2B. There is no question that this type of physical evidence falls squarely within the defendant's required reciprocal discovery obligations." That's Knight 256 NJ 404, 422, 2014. The court distinguished previous cases before the court in State v. Mingo and State v. Williams of turning over inculpatory evidence. The court in Knight also rejected Sixth Amendment concerns. Quote, "No such concern is present in this case, however, in which the item in question is physical evidence and not the product of defense counsel's investigations." That's Knight at 423. Significantly, Knight uses the phrase, quote, "potentially in defense counsel's possession," rather than actually in defense counsel's physical possession. In this case, we know that defense counsel physically had possession of a screenshot of a communication between Caitlin Caneiro and Jennifer Caneiro, where the document specifically shows that at some point in time, the text message was read. That item was never turned over to the state at any point in time until well after the testimony. The court now applies this legal framework to the two pieces of electronic evidence at issue in this case, beginning with the text message screenshot. Here, the text message screenshot depicts electronic metadata showing that a message sent by Katie to Jennifer now displays a status of, quote, "read," end quote. First, as to the origin of the screenshot, the, quote, "read," end quote status was created by the iPhone messaging system, not by defense counsel. When Jennifer Caneiro's phone or other device logged into her iMessage account, opened Katie's message, the messaging system automatically generated the, quote, "read," end quote status and transmitted that information back to Katie's device. This is a function of how the iPhone iMessage system operates. It's not something that defense counsel created, directed, or had any role in producing. Similarly, the screenshot itself was created by Katie Caneiro, not by defense counsel. Katie took the screenshot on her own phone and then transmitted it to defense counsel. Under Knight, this electronic evidence, quote, "falls squarely within defendant's required reciprocal discovery obligations," end quote, because it is, quote, "not the product of defense investigation or attorney work product," end quote. Second, as to the discoverability, the text message screenshot unquestionably qualifies as electronic stored information. It is a digital image file depicting electronic metadata from an iPhone messaging application. It is stored on Katie's phone and was transmitted electronically to defense counsel's phone or computer. This is precisely the type of electronic evidence that Rule 3:13-3B2B contemplates. Moreover, defense counsel actually received that screenshot on February 8th, 2026, according to defense counsel. Defense counsel had that screenshot in her possession when Katie testified on February 9th, 2026. Thus, defense counsel had actual physical possession of the electronic file. The fact that defense counsel chose not to introduce the screenshot as an exhibit at trial does not change the discovery obligation. Defense counsel's strategic decision about how to use the evidence, whether to present it through testimony describing it or through introduction of the exhibit itself, does not eliminate the requirement to disclose it to the state. It's Discovery Rule 3:13-3B2B. Finally, the defendant's argument assuaging noncompliance are unavailing. under Rule 3:13-3F, there is a continuing duty to provide discovery. The fact that the defense counsel received the screenshot only one day before Katie was scheduled to testify, according to what she has said, does not excuse the failure to disclose. Further, the defense's reliance on tier misunderstands the distinction between tier and night. Tier protects defense counsel from being compelled to create written summaries or oral written statements. Tier does not protect defense from disclosing independently created evidence that defense has the ability to obtain and had it in her possession. Because the screenshot was created by Katie and the messaging system, not by defense counsel, Knight requires disclosure regardless of whether defense counsel ultimately introduces it as an exhibit. Therefore, this court finds that defendant violated its discovery rule obligations as it relates to the text message read status of the text message between Katie Caneiro and Jennifer Caneiro. As to the GPS, the iPad location data was created by a location sharing service or application, not by defense counsel. While the parties have not identified the specific service Katie used, common location sharing services include Find My Phone by Apple, Life 360, Google Location Services, and similar applications. These services use GPS technology to track the location of devices and share that location information with authorized users. When Jessie Caneiro's iPad shared its location with Katie's device, the location sharing service generated GPS coordinates, timestamps, and other metadata showing where the iPad was located at various times. This data was created by the technology, not by defense counsel. Defense counsel played no role whatsoever in the genesis of this electronic evidence that was created by the witness's actual iPhone. First, location sharing data is unquestionably electronically stored information within the meaning of Rule 3:13-3B2B. The rule specifically requires disclosure of electronically stored information and any other data or data compilations stored in any medium. Defense counsel states that the defense simply has what was verbally relayed during a recent witness prep session. However, the test under Knight is not limited to evidence that defense counsel has already obtained and is physically holding. Knight uses the phrase, quote, potentially in defense counsel's possession, end quote, indicating the test extends to evidence that the defense counsel has the ability to obtain. Defense counsel argues that Tier protects Katie's testimony about what she observed because defense counsel has no written statement or document to turn over. Defense counsel contends that Katie simply told counsel orally what she saw, and Tier holds that defense counsel need not create a written summary of the oral statement. This argument fails for the same reason it fails with respect to the text message screenshot. The issue is not whether defense counsel must create new work product summarizing what Katie said. The issue is whether defense counsel must obtain and disclose independently created electronic evidence that exists separate and apart from any work product, or at least to ask about it. Caitlin Caneiro did not merely remember seeing something. Katie used a location sharing service that generated electronic data. That data exists or existed in electronic form. It was created by technology, not by defense counsel. If defense counsel had the ability to obtain the data from Katie, then defense counsel should have requested it or at least indicated to the state that it does not exist. Tier protects, as I indicated, work product created by defense counsel. Tier does not protect defense counsel from the obligation to obtain and disclose independently created electronic evidence within defense counsel's control. I should also point out, as it relates to the location sharing that defense counsel indicates in a footnote on page 2 of her brief that she must have learned through her conversation. I'll just use her words. It should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it, either via text message or phone call, once she saw that she had the location, and asked him why he taken Jesse's iPad. Why he had taken is probably what she meant to say. Corey then turned off the location. However, so in that circumstance, that is more information that if the state had that information in advance, would have had the opportunity to actually investigate whether that phone call or text message actually existed, had the opportunity to reach out to Corey Caneiro, and if they wanted to or so choose, to figure out if that existed, to get other phone records in this particular case, which at some point they did not feel that they needed at the time that they originally interviewed her. What happened here is that defense counsel put the state in a position by not providing any information as it relates to that metadata for the location services, puts the state in a position where they did not have the opportunity to even investigate, which is exactly what I said from the beginning that State versus Knight talks about, that the thrust behind reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. Okay. So, with that being said, defense counsel devotes substantial portions of the written submission to arguing that Katie Caneiro was available to the state for more than 6 years, and that if the state wanted to learn about the evidence, the state could have re-interviewed Katie at any time. This argument fails to excuse the discovery violation for several independent reasons. Number one, discovery obligations are independent of the state's investigation. Under Rule 3:13-3B, it imposes discovery obligations on the defense that exist independently of what investigative steps the state has or has not taken. This rule does not contain an exception stating that a defendant need not disclose evidence if the state theoretically could have discovered it through independent investigation. If defense counsel's argument were accepted, it would eviscerate the reciprocal discovery rule. Under defense counsel's theory, a defendant would never have to have a discovery obligation with respect to any evidence that the state could have found on its own through a diligent investigation. This would include written statements, documents, physical evidence, and electronic data. The defendant could simply wait to see what the state discovers and then spring any additional physical evidence or electronic data, arguing that the state should have investigated more thoroughly. Second, the evidence did not exist when the state interviewed Katie. Defense counsel argument in that area also fails. The state interviewed Katie Caneiro on November 20th, 2018, the day after the murders. At that time, the text message did not yet display a read status because Katie had not yet checked it after Jennifer's death. At the time, Katie had not yet tracked the iPad location of Corey's residence because it did not occur until February 2019, several months later. The state cannot be faulted for failing to ask Katie about evidence that did not yet exist at the time of the interview. The notion that the state should have conducted follow-up interviews with Katie every few months for the next 6 years on the speculation that she might someday check our old text messages, track an iPad location, is unreasonable, and this court finds no support in law. Defense counsel argues, as a third point, that it would be unfair to penalize the defense for recently learning information that the state could have discovered years ago. This argument actually supports the state's position rather than the defendant's position. If the timing of when parties learn information matters for purposes of fairness, then the relevant comparison is not between when the state first interviewed Katie in 2018 and when the defense counsel interviewed Katie in 2026, The relevant comparison is between when defense counsel learned about this evidence and when the state learned about it. Defense counsel learned about the iPad location on either January 30th, 2026 or February 8th, 2026, based upon defense counsel indicating that she had prepped Katie Caneiro for the first times for her testimony on these two particular dates. Defense counsel obtained the text message screenshot on February 8th, 2026. Katie testified on February 9th, 2026. Defense counsel had somewhere between 1 day and 10 days to disclose not just the evidence for the text message, but also the iPad location information so that the state could have had the opportunity to take a look at it and investigate it. The state has literally had zero time to investigate any part of this information, to verify it, to contradict it, to subpoena for more information, or anything in that matter. If fairness and timing matters, as defense counsel argues they do, then the fair result is to give the state the same opportunity to investigate that defense counsel had. That is precisely why a continuance would be accomplished if it was requested by the state. There are questions here that the state cannot answer simply through cross-examination of Katie Caneiro. These questions potentially require investigation, consultation with technical reports, forensic evidence of Katie's phone, review of service provider records, and potentially interviews of other witnesses, including Corey Caneiro himself. The state cannot conduct this investigation while Katie is on the witness stand testifying before the jury. The state would need time to investigate before the evidence impacts jury deliberations. The state has indicated before they heard my decision that they would that they did not want a continuance for any reason. However, before I finish this opinion, I'm going to give them the opportunity, after hearing the opinion, to make any decision that they would like to make. The court is relying on 3:13-3F, where the trial court is afforded wide latitude to resolve discovery disputes. Moreover, in appropriate circumstances, the court can either order discovery of items beyond the scope of the discovery listed in Rule 3:13-3. However, in this case, under the circumstances, the court is not going to use the draconian remedy of actually barring some of this evidence, and I'll go through it in a minute, but the court would consider a continuance for the state if they needed more time to look at this. However, let me say this. As it relates for the rationale behind the reasoning for the GPS testimony, which the defense says this testimony is relevant because, and this is relating to the GPS location of where Jesse's iPad was located, for two reasons. One, it demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vogt.
My apologies, that was the third time.
Can we go off the record for a second?
Judge, Good.
Okay. For the record purposes, an individual was removed from the courtroom for reasons for the Sheriff's Department to take care of. I just want to go back and say for the two reasons why the defense believes that this is admissible. The GPS locations. It demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vogt regarding the Tiffany's jewelry boxes found on top of the fire rubble, both of which occurred prior to Vogt's collection of DNA samples in 2020. Second, that it demonstrates a failure to investigate for whatever reason. The police did not seize or search the iPad, while they did seize or search Sophia's phone. I will take them in order. As it relates to any type of Corey's taking of these items out of the house after the homicide, the court had rendered a decision on January 27, 2026, in a 42-page opinion outlining what behavior that and what instances that would be allowed to be elicited by the defense of either Corey Caneiro or if there were certain other witnesses that took the stand as it related to Corey Caneiro. The court, in that order, court specifically said that it was found as wholly inadmissible any alleged post-crime suspicious activity involving Elisa Caneiro and Corey Caneiro. In this circumstance, the allegation that Corey went into the home and took out the iPad, allegedly, because at this point in time, there's testimony about a GPS location. I don't know if the state's going to end up asking for for a period of time to actually look at the witness's phone to find out if the GPS actually is there or not. But right now, we only have testimony about that. And the reality is, I have no evidence in this case other than that at some point in time, potentially, Corey had Jesse's iPad. I was supplied in the submission by the defense a photograph of the kitchen of Keith Caneiro's home that had an iPad there. That iPad, whether that's Jesse's or not, that's what is being offered by the defense, that it's Jesse's, and that Corey may have taken it. But Corey also was responsible for taking over everything after Keith and his entire family was obliterated from this planet, and Corey was left to handle all of the issues that were relating to the estate of this. So I can't find, under these circumstances, that Corey taking items from the house is relevant. I find that under 403 that it actually would be a confusing issue for the jury, because the probative value is significantly outweighed by the prejudicial effect of trying to understand first, was it Corey that actually took it out of the house? Was it somebody else that took it out of the house and gave it to Corey at some point in time? Was it, who knows? The answer is that no one knows that. There's no testimony to that. There's no connection that has been shown, at least at this point in time. So the fact that the allegation is that Corey took items out of that house is not something that this court finds that would overcome a 403 analysis. The second issue is one that's something that's more in line with what I can understand. The second issue deals with a failure to investigate because the police did not seize and search the iPad while they did seize and search Sophia's phone. As it relates to what the investigation revealed and what it may not have, what they did and what they didn't do, that is relevant overall in this particular case. The issue in this case is whether there was other evidence in this case that would point to a different individual other than Paul Caneiro. And the investigation and looking into other areas such as the iPad, I do find to be relevant. I do not find under 403 that its prejudicial effect would be outweighed by the probative value. So I am going to, for purposes of this testimony, I will allow the fact that the iPad has been was taken out of the home. However, the testimony as it relates to the GPS location is something that I'm going to strike from the record. There is no relevance to that other than under 403 as an overall thing, that there would be a confusion, that the prejudicial effect because of that confusion outweighs any probative value. So we can handle that in one of a few ways. Number one, there can be an agreement that Jesse's iPad, that there can be a stipulation that Jesse's iPad was not searched, was not taken and or searched, or some other type of stipulation that you can come up with. But there will be no testimony as it relates to this iPad until someone can give me a proffer in advance of exactly what's going to be said about it. Defense counsel, out of fairness to the defense, offered up some suggestions. I'll leave it to the state and the defense if they want to come up with something that would be that they feel would be fair to both sides. However, the admissibility of the GPS location as it relates to the two reasons why that the defense wants to bring it in, the court does not find under those circumstances that it would allow the GPS location in. Again, it will allow the fact that the iPad was not seized or searched, but as it relates to GPS location, this court has difficulty with understanding how there is a connection between where the iPad was located, especially when the defense is specifically saying in their submission that they are not saying that the iPad was taken during the murders, that the iPad was located still at the house after the murders, that there's no connection to Corey Caneiro or third-party guilt as it relates to that particular iPad. That I do not find a connection there under Kodadich, and I would not allow that in for purposes of any third-party guilt. But like I said, I would consider it for purposes of a failure to investigate. As it relates to the text message, as I indicated, I'm going to ask the state now if the state would like some time to investigate and or whatever that they need to do, I would entertain that. If the state decided that they did not want time to investigate, I am going to give them latitude as to the cross-examination in this specific area of the witness as it relates to that screenshot and how it was provided, when it was provided, and how that all took place. So with that being said, that's the court's decision that even though I do find discovery violations on both, I find that under these circumstances that the draconian remedy of excluding them for the reason of a discovery violation is not what this court is doing. However, in looking at the actual items, I have made rulings as it relates to my understanding of the evidence rules and how it should be allowed in or not allowed in. So with that being said, to the state, I'll give you the opportunity to let me know if you want what your preference is under the circumstances, and also if you want some time to speak to counsel as it relates to a stipulation as to the second part of Jesse's iPad.
Sure, Judge. I think Ms. Wallace is going to talk to Ms. Mastalone about the iPad. I'm going to go inquire. I highly doubt I'm going to ask for any more time, other than 10 to 15 minutes, just to think about it.
Okay.
The only question I had, Judge, with respect to clarification of the
Sure.
court's order, obviously they heard it was read, part of that testimony, but we got that document in the brief last night. Is the defense allowed to utilize the actual screenshot?
Well, let me ask you this question. Does the state, under the circumstances that it's been put in, would you want to use that on cross-examination and to go in the circumstances surrounding that testimony that you already have? Because, as I indicated, I'm going to give some latitude because of the fact that I do find it is to be a violation, but I do find that under these circumstances that I'm going to allow it in because somebody opened it. It's already out there. And I don't think that I can clear that out of the jury's mind. And I think it's really, at this point in time, the preference of the state. And again, if you want a few minutes to think about that, I'll give you the opportunity to do it. And again, if you need more time, then all you have to do is ask for that. And out of fairness, I would give you that opportunity to have more time. I don't want anyone, either side here, to sit here and worry about the trial and how long the trial is going or how quickly it's going. It's truly your own prerogative for the state, and you and Ms. Wallace should have the opportunity to think about it now that you have my decision.
Okay, Judge. Yeah, I would just like a little bit of time to think about that.
Okay. Why don't we meet back here at 10:45? I'll give you 30 minutes. If you need more time, you can let me know. We're going to tell the jurors downstairs we're in a little bit of a holding pattern, and I'll have them more do that. I won't address them myself, just to let them know so that they get an idea of what's going on. Okay?
Thank you, Judge.
All right, thank you. Cross-examination of the
Out.
detective vote.
My apologies, that was the third time.
Can we go off the record for a second?
Judge, why?
Okay. For the record purposes, an individual was removed from the courtroom for reasons for the sheriff's department to take care of. I just want to go back and say for the two reasons why the defense
Court is back in session.
Okay. Everyone can be seated. I'll see the attorneys at sidebar.
Sure.
Ladies and gentlemen, we're going to break to give the state a little bit more time. We'll start back up at 1:30. jury. Mr. Decker, can you tell us where we are?
Judge, I think we're ready to continue with the direct examination of Ms. Caneiro.
Okay. Have we come to an agreement as to when we're going to deal with the stipulation issue?
I think before we leave for the day, we can give that to the court. I mean, I think it's like one sentence. One of us just has to write it out.
Okay. All right. Defense, anything else that we need to put on the record before I bring out the jury?
Not at this time, Judge.
Okay. We can ask the jury to come back out, please. Good afternoon, everyone. You can be seated.
Good afternoon.
Thank you all for coming back this afternoon. As I indicated this morning, we had a legal issue. So if you want to have a doll, like a Mark Lemieux doll that you want to use to kind of stab at for being late, you can blame everything on me, on nobody else. Sometimes things take longer than expected, but we are ready to proceed at this point in time. So thank you very much for your patience, for coming back for the afternoon. We really do appreciate it. Thank you on behalf of everyone here. We're back on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. And I have the appearances of counsel for the record.
Good afternoon, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good afternoon, Judge Chris Decker for the state.
Good afternoon, Your Honor. Monica Castellan on behalf of Mr. Paul Caneiro, who's present.
Good afternoon, Andy Burnett for Paul Caneiro. Okay, good afternoon, everyone. Good afternoon, Mr. Caneiro. We'll continue on with the testimony of Caitlin Caneiro. If she can be brought back up, please. Just watch your step, please, if you don't mind. I want to remind you, you're still under oath from yesterday, okay? We can continue on with the direct examination. Go ahead.
Thank you. Good afternoon, Katie.
Good afternoon.
So, just a couple more topics I wanted to cover. One of them I wanted to circle back to was, I think you testified yesterday about the Porsche Macan.
Yeah.
And I think you mentioned it was a loaner vehicle.
Yes.
Approximately how long did your dad have the loaner vehicle for?
I'd say less than a week.
And why did he have a loaner vehicle?
His car was in the shop. I don't remember why.
And with respect to, we also heard a little bit about soundproofing in your house through some testimony. Was the master bedroom of the house soundproofed?
Yes.
And what about the basement?
Yes.
Okay. And to your knowledge, who did the construction of who did the construction of the remodeling, including the soundproofing?
It was Corey's best friend, Tom Z.
And as the construction and the soundproofing was happening, was Corey ever there at any point?
Yeah, he would stop over, and him and Tom Z would go get lunch together occasionally.
Now, we've also heard testimony about a little bit about a backpack. Did your dad have a backpack?
Yeah.
And is that something that, did you see him carry it around?
Yeah, he carried it everywhere. It was almost like an extension of his wallet. Like everywhere he went, the backpack went.
And for how long would you say that to your knowledge, your dad had the backpack?
I don't know exactly, but at least since I've been in high school.
So
At that
approximately
time, around 10 years.
10 years. And just a couple questions about your dad. Can you tell us a little bit about your dad as a dad? Was he a good dad or?
Yes.
Objection.
It's irrelevant. It's irrelevant. Sustained.
Okay. How about your dad as a brother? How was his relationship with Keith?
It was very good. They were very close. They did everything together.
And what about your dad as an uncle? How was he with Jesse and Sophia?
I mean, he treated them like he treated me and Marissa like his own kids, and he would drop everything for us. He'd always be there. He was very supportive. He was just good to have around.
What about specifically about Jesse? What, if anything, can you tell us about their bond?
They had a great relationship. They had a lot of things in common. Jesse loved history. My dad loves history. So they would do a lot of things like that. When Jesse was learning how to swim at the Sultan Club, he asked my dad, who I tagged along with, and we watched his like little race when he learned to swim. And then one time, I think Jesse was in preschool, he was able to bring like a special friend to show off to his class, and he invited my dad.
Did your dad and Jesse ever do things together, like lunch or anything like
Yeah,
that?
they did a lot together. When Jesse was bored at home, he would call my dad to hang out. And either Jesse would get dropped off or my dad would go there. But they did a lot together.
That's all I have. Thank you.
Cross.
Ms. Caneiro, it sounds like the children, Jesse and Sophia, would have trusted your dad, right?
Yes.
Now, do you recall yesterday there was some testimony where you had sent your Aunt Jen a text message on November 20th in the morning of 2018?
Yes.
Okay. And I think you said you sent the text message at about 10:26 a.m.?
Yes.
And your phone number ended in, it was 7924, is that correct?
Yes.
I'm just going to approach you with D154, which you've seen yesterday. And I believe that was what was shown to you yesterday, is that right?
Yes.
Okay. Now, this message, it's actually on the back page of it. The green bubble here where it says, the text message to her, "Where are you?"
Yes.
Does it show as being read on here?
No.
Just delivered, right?
Just delivered.
Okay. And then I think you said you looked at it later and eventually you saw that it was read.
Yes.
Now, does this appear to be a group text message? Oh, let me ask you this. Do you see these numbers here right before it, the first number?
Yes.
Is that says owner? Is that your number?
Yes.
And that ends in the 7924 number. Is that correct?
Yes.
And then you have Aunt Jen's number here.
Yes.
And then this 848 number. Do you see that number?
Mm-hmm.
Do you recognize that?
No.
Is that a number associated with EcoStar?
I have no idea.
You don't know. It was in your group text message, though, right?
There was no group text message with my aunt.
Okay. Well, then what is this?
I don't know.
Objection?
We talked about.
Overruled.
Okay. Let me show you. I'll show you something else. Miss Caneiro, did you have another phone number at the time or another number that was associated with your phone?
Whenever I traveled to Greece, I had a different SIM card.
Did you have a different phone number?
It was a different SIM card, so yes.
So he has a different phone number?
Yes.
Yes? Okay. And that other phone number, was that 732-268? No?
No, it was a Greek number.
Okay. I'm going to show you what has been marked, and I'll show council as S504. First page of the extraction report. First page of the extraction report. May I approach?
You can.
Okay, I'm going to show you what has been marked as S504. This is the first page of your extraction report from your cell phone. And let me just ask you, you recall that your cell phone was extracted back in 2018, right?
Yes.
Okay. I'm just going to show you if you recognize this number here. This 7924 number. Do you recognize that? Mm-hmm. Okay. Is that your number?
Yes.
And that's the number you texted Aunt Jen from, right?
Yes.
And then this number here that ends in 8977. Oh, wait a second, I'm sorry. It's actually 9357 right there. Do you see that?
Yes.
Okay. That's on the extraction report. Do you recognize that phone number?
No.
You don't recognize that? Okay.
I'm showing approaching with S505.
If we could take a look, I'm going to show you first D154. This is your text message, right, to your Aunt Jen on 11/20/18? Mm-hmm. Okay. And I'm going to
You
show
have
you.
to say yes or no.
Yes.
I'm going to show you what's been marked as S505. Do you recognize that same text message on here?
Yes.
Okay. And does that appear to be part of a group text message?
No.
It doesn't?
It's not a group text. It's a conversation between me and my aunt.
Okay.
On the previous day.
But do you see the numbers up here where it says Aunt Jen and then it has the 848 number and the other number that is marked 357? Do you see that?
I see it, yes.
Okay. Does that appear to be a group text message?
I don't know. I don't see any other text messages. This is, if you look at my phone, it is a conversation between me and my
Okay.
Aunt Jen.
Ms. Caneiro, I'm going to ask you a couple of questions just to clarify some of the cars that you guys owned. So, you indicated your dad owned or drove a white Porsche Macan, is that right?
Yeah, this was a turbo.
Okay, and I think you said his car was actually in for service, so he had a loaner car. And the loaner car that he had on 11/20/18, that was also a white Porsche Macan, is that correct?
Yes.
Okay, and it had like the black strip on the bottom doors?
I'm sorry?
I don't remember.
You don't remember? Your mom's car, the car that she drove was a Porsche Cayenne, is that correct?
Yes.
Is that the car she routinely drove?
Yes.
And that's the car your dad pulled out of the garage, is that right?
Yes.
Now, did that car have a remote garage door opener in it?
Yes.
It did, okay. You had an alarm system in your house, isn't that correct?
Yes.
And did you have multiple cameras in your house?
Yes.
So you had an alarm system. Did you also have a DVR system that was separate?
I don't know how it works, but
Okay. So you had an alarm though system that was hooked up to your house?
it was, but it never works, so.
Okay. Certain doors like would beep when you were
Yes.
coming in and out, and then some doors didn't beep, right?
Yes.
When you were coming in and out. All right, so you had that, and then you had some cameras inside your house, is that right?
I know that now. I didn't know that back then.
You also had cameras outside your
Outside,
house,
I
is that
know that.
correct? And then you had like a DVR box that was located in the garage, right?
yes.
All right, so I would imagine at night you kept your doors locked, is that right?
Yes.
Now, the doors that would beep when you would go in and out, that would be the front door, is that correct?
Front door, yes.
And then the garage doors?
Both of them, yes.
And was there another one?
Yeah, the back door in the laundry room.
Back door. Now, the French doors and the sliders, they would not beep, right?
No.
If you're coming in and out. And where were those doors located?
The slider doors were in my kitchen, and the French doors were in the dining room.
Okay, and did they lead right out to the backyard?
To my deck,
To the deck,
which was
okay.
in the backyard, yes.
Now, you indicated that your dad's room was the guest room, is that correct? And was that room, if you go up the stairs, would it be all the way to the left?
Yes.
And then next to his room was your room, right?
Yes.
And then next to your room was your sister's room?
Yes.
Marissa's room? And then was there a bathroom after that?
Yep.
And then the master bedroom, right?
Yes.
Okay. And the master bedroom, that was the side that was closest to the fire, right?
One part of the master bedroom. I mean, it wasn't the bedroom, it was the closet and the bathroom.
So it like shared a wall with essentially where the fire was?
The fire started in the basement, and it went up the back of my house, which was the master bathroom and the master bedroom, not the bedroom. Master closet, not the bedroom.
Okay, so the master bedroom closet was where
Yes.
the fire started, right?
No, it ended in the closet.
Okay, but it was on that side of the house, you
Yes.
understand what I'm saying?
Yes.
Okay.
But the
Your
bedroom
mom-
went all the way across.
Understood. It wasn't closest to your dad's room, right?
No, it was closest to the master and my sister's side of the house.
Got it. Now, your mom, you guys had some Australian sheepdogs, is that right?
Yes.
2 of them?
Yes.
Okay. And I think you indicated, or you may have been indicated that they were with your mom in bed?
That's where they slept in.
Did you ever hear them barking in the night?
No.
Now, on 11/19 of 2018, you worked all day?
Yes.
And then you got home at, I think you said at about 6:15, correct me if I'm wrong.
I don't remember the exact time, but 5, 6, yes.
Okay.
That sounds normal.
Were you the last one to go to bed that night?
Yes.
Your sister and your mom went to bed before you, is that correct?
Yes.
And you went up to bed at about 11:30?
Yes.
Now, when you came home, your dad was already up in his bedroom in the guest room, is that correct?
Yes.
Okay, and you did not see him the rest of the night, is that right? Okay. I know you indicated, I think, on direct examination that he was sleeping?
Yes.
Okay. You didn't see him though, so you can't say what he was doing, is that correct?
No, I didn't go in his room.
Now, obviously, you wouldn't be able to see anything or hear anything that he may or may not have done when you were sleeping, is that correct?
What? Sorry.
You were not able to see your dad, anything he may have been doing in the middle of the night while you were sleeping, is that correct? And he was the first person you saw the next morning, is that right?
Yes.
He was the one that woke you up?
Yes.
Yeah, so obviously he was already awake before you were awake, is that correct?
I took sleeping pills the night before, so I did not hear the fire alarm.
Okay. But he was awake prior to you being awake, is that correct?
Yes, I was the last one awake.
Okay. Now, you mentioned on direct examination that your dad kept some of his guns in the unfinished part of the basement. Is that right?
Yes.
Is there like a metal locker down there?
I don't know what it looked like. Like, I know the area, like I would be able to recognize as my basement, but I don't know exactly.
Okay. But his guns were kept, you said, in the basement?
In a, like a locked area, I guess.
And also there was a safe in the garage too, is
Yes.
that right? Okay. But that wasn't the only place that your dad had his guns, was it?
To my knowledge, it was.
You weren't aware of a Sig Sauer gun that was located in the guest bedroom with a laser light in it?
I don't know what a 6 hour is.
Do you know what a laser light is?
I mean, it's a laser, that's a light.
Do you know what it is or no?
No.
Okay. You don't know what it's used for?
No.
Now, your dad was good with IT and tech-related things, is that correct?
It was what he did for a living, so yes.
And he installed the cameras in your home?
Installed, I wasn't there for it. I have no idea.
Did he set the cameras up in your home?
He used the cameras.
Okay. And would he maintain the cameras?
Yes.
He would be the one to handle anything camera-related?
Yes.
Okay. Do you know that he also installed, and you may know because you were sitting here, Dr. Gold's cameras?
I know that now.
You know that now? Okay. If anyone in the home would know where the DVR was located, the box, it would be your dad, right?
We all knew.
Including your dad, right?
Yes.
He was the one that maintained the cameras, correct?
Yes.
Do you remember an officer approaching you and your father on the morning of 11/20 and asking your dad where the DVR system was located?
I don't remember, but I saw it here. I was here.
It's not here.
Yeah.
You don't remember that, but you remember your dad saying, "Oh fuck, I hurt my hand." Just
Yes.
to be clear. Okay. Let's play, if we could, you have permission to play S78, which is the DVR of that portion of the testimony. And I'm just going to pause it. You can see the timestamp. Okay. Okay. Ms. Caneiro, I'm going to ask you just to watch this, and I might pause it and ask you a couple of questions. You can begin. Can we just have the court volume up, please? Pause it, please. Do you recognize the individuals on the screen or any of them?
Yes, my dad and my mom.
Okay. And whose car is that in the back?
My mom's.
The white Porsche Cayenne?
Yes.
Okay. You can go ahead.
It's your house? Yes. Where is that?
It's me, not my mom.
All the DVD stuff and the cameras and everything in the house. It's in the garage. In the garage? Yeah. Where in the garage?
All right, I just want to be clear. Did you see when your the officer asked you where all of the cameras were located? Did you see that part? Yes. And your dad looked at you and you said the garage. Did you see that part?
Yes.
Okay, go ahead.
Okay.
You walk in the garage and it's all the way up top to the left.
Okay.
And then the officer asked specifically where in the garage, correct?
Yes.
And your dad looked to you and said,
He was talking to both of us.
Okay, my question was, your dad looked at you and said, is that correct?
Yes.
Okay. And then you told the officer specifically where the cameras were located, is that right?
Yes.
Do you have it running right now?
I've been having problems with stuff in the garage.
You've been having problems with stuff in the garage?
Yeah.
Okay.
I've been picking up an accident with one of the companies.
Okay.
You can actually take this down. Now, did you hear your dad at that point say that he had been having problems with stuff in the garage?
Yes.
And that he had a ticket open with one of the companies?
Yes.
Okay. You had no idea what that meant, is that correct?
No.
Yes or no?
I said no.
It's not correct.
No, I don't. I had no idea.
You didn't know what he was talking
No.
about? Because according to you, prior to you going to sleep that night, the cameras appeared to be in working order, is that correct?
I didn't check, but I would assume so.
Okay. And do you recall saying that in your statement that you gave to the police?
Yes.
Okay. That the cameras appear to be in working order prior to you going to sleep?
Yes.
Can I just see D1, 425 to 430, please? D1, 425 to 430. I'm approaching with what has been marked as D425 first. You were shown this picture the other day, is that right?
Yes.
Okay, and that's a picture of your mom, your dad, and Jesse and Sophia, is that right?
Yes.
And about how old are they here?
I would say 4, 2.
2 and 4? I'm going to show you what's been marked as D426. Do you recognize that?
Yes.
And who is that?
Jesse and my dad.
And how about how old is Jesse there?
3.
3. Showing you what's been marked as D427. Is that your dad and Sophia?
Yes.
How old is Sophia about there?
2.
Showing you what has been marked as D428. Do you recognize that one?
Yes.
That's your dad and Sophia, right?
Yes.
And how old is she there about?
3.
3. Showing you what's been marked as D429. Do you recognize that?
Yes.
And what is that?
Jesse and my dad.
Okay, and about how old is he there?
5.
5. Okay, and then I'm showing you finally what's been marked as D430. Do you recognize that?
Yeah.
And is that Jesse and your dad?
Yes.
And about how old is Jesse there?
5.
When Jesse passed away, he was 11, right?
Yes.
And Sophia was 8?
Yes.
Okay. So of the photos that you chose to sample for your dad's special bond with the kids, they were older photos, is that correct?
I mean, yes, because that's all we have.
Older
All I
photos?
have. Yeah.
You indicated that your dad and your Uncle Keith were close, is that correct?
Yes.
Were you aware that they were so close that your dad was actually the trustee for your Uncle Keith's life insurance trust?
Yes.
You were aware of that?
I'm aware of that.
You were aware that they spoke daily, I believe you said too, right?
Yes.
Okay. Were you aware that your Uncle Keith actually called your house line on the night of November 19th of 2020?
I was at work, so no.
So you were not aware of that? Were you aware that your Uncle Keith actually spoke to your mom once that night?
I know now, but no, I was
didn't
not
know
aware
that.
that day.
When your dad told you about the 4 text messages that Uncle Keith sent him in the middle of the night, he didn't tell you about those 2 phone calls?
No.
No. And by the way, the 4 text messages, when did your dad tell you about that?
That morning,
About when?
9:30 or 10.
Your mom she did not work outside the home, is that correct?
Sorry, no.
Do you recall her ever working outside of the home since you were born?
Yes.
You do, okay. About how long did she not work outside of the home for?
Probably since I was in first grade until after this.
Okay. And your dad was the one who paid the bills, is that right?
I have no idea.
Okay, you're not sure?
No.
Just speaking of bills, you guys had, there were 2 Porsches that we heard about that your parents each drove, is that right? And then, what kind of car did you drive?
I drove a Porsche Carrera S,
Okay, and how about your sister?
Jeep Wrangler.
Okay. Did any of your family members drive an Audi?
No.
No?
Oh, wait, Keith.
Keith
Had an Audi at one point. I don't remember if he had it then, but
2018.
okay, no.
Did your dad pay for Keith's Audi?
I have no idea.
Now, you testified on direct examination that when you were about halfway down the stairs, you remember a loud bang, right? And yes? And then your dad saying, quote, "Oh fuck." Do I have that quote right? Or "oh fuck my hand." Is that right? Okay. When in the last 7.5 years did you remember that little tidbit?
The whole time.
Because you didn't seem to remember it when you gave your statement back on the date that it actually happened. Right, it's not in your statement?
It's not in my statement, no, because I was asking to leave, and they kept telling me that my cousins were okay and they would take me after my statement, so I wanted to get through it.
But 7.5 later, you come in here and you remember it today.
Why would I forget that?
Kind of like 7.5 years later, you decided to check the status of your Aunt Jen's text message, right?
Yes.
What prompted you to do that, by the way?
Because we were talking about her?
You hadn't checked it from the time you sent it, though, correct?
Not since that day.
Okay. And then, I think you said you checked it a couple of days ago, right?
Yes.
So, a couple of days before you were coming in to testify on behalf of your dad, right?
Yes.
With regard to your dad's hand injury, you didn't actually see him get the injury, is that correct?
I didn't see him hit his hand, no. I heard
You weren't
it.
even sure which hand it was, is that right?
No.
Just the last couple of questions, Ms. Caneiro. You were obviously close with your Uncle Keith, is that right? Yes. And your Aunt Jen, and your cousins, Jesse and Sophia.
Yes.
And you're close with your dad, is that right?
Yes.
You guys have always had a close relationship,
Yes.
and you've maintained that relationship throughout the years, is that correct?
Yes.
And you're here today testifying on your dad's behalf, is that correct?
Yes.
And you don't want to see anything bad happen to him, right?
What's worse?
You don't want to lose him too, is that correct?
It's already been gone. There'd be nothing that would change.
Any redirect?
Judge, can we approach?
whenever you're ready.
Just a few follow-up questions. Starting with the text message with your Aunt Jennifer, do you still have that text message in your phone?
Yes.
As you sit here today?
Yes.
And earlier today, did you have an opportunity to show it to the prosecutors?
Yes.
Okay. And from what you can tell on your phone, is it a group message or not?
It's not a group message, and if it was, you wouldn't be able to see that it's red. Group messages don't work like that.
Obviously, you didn't have access to your extraction report, correct?
No.
Now, you were also asked on cross-examination about the cameras in your house.
Yes.
And in your statement to the police, I think the prosecutor asked you, to the best of your knowledge, or they were working at the time.
Yes.
Okay. Did you specifically check your cameras the night before?
I said, no, I didn't. I wasn't one to check my cameras ever.
Okay.
That's something I did.
So when you told the police that your cameras were working, what did you mean by that exactly?
I mean, I wouldn't see why they wouldn't be working.
Okay. But was there, returning back to your testimony about the 18th and what was happening earlier that day, what was...
We were having issues with our Wi-Fi that weekend leading up, and I don't know if it was resolved. I went to work the next day. I wasn't there all day.
And the prosecutor also talked to you a little bit about, I guess, whether you ever heard your dogs barking at night.
Yeah.
At the time that, and during the overnight hours, where were the dogs?
In my mom's room.
Okay. And did you mention earlier, is that the master bedroom?
That's the master, yes.
And is the master bedroom to some extent soundproof?
Yes.
And the last thing I want to ask you about is the prosecutor asked you about your statement and things that you didn't
Yes.
maybe mention during your statement. And I think you started to get into it, but what were the circumstances that you were giving, under which you were giving that statement?
I kept asking about my cousins, and I was being told that once I gave my formal statement, I would be brought to them at wherever they were located, whether it was a local hospital somewhere. And I had no idea what was going on. I had no idea anything about that day, and my statement was a basic statement. I was trying to get out of there. I wasn't sitting there going, no one was telling me anything. They just asked me what happened that day, and I briefly said what happened that day.
Did you know at the time what was important or not important to mention?
I had no idea what was going on. No one was giving me answers. I kept asking to leave, I kept asking to find people, I kept asking what was going on, and they would just move past and say, like, we'll answer everything when you're done.
That's all, thank you.
Recross.
Very quickly, Ms. Caneiro, the DVR system that your cameras were hooked up to, that was actually hardwired, and Wi-Fi would not have affected it. Is that correct?
I have no idea.
You don't know, okay. And then just in terms of you being at the police department, and you indicated they wouldn't let you leave, right?
Yes.
It's fair to say there was a fire at your house, right? At that point, there had been a
Yes.
fire, and then there was a fire at your Uncle Keith's house, right?
Yes.
It was important for them to figure out how these fires might have started and who could have started them. Is that correct?
Yes.
And your safety was also important because at that point,
My safety. I was having an asthma attack and they wouldn't let me get my
Ma'am.
inhaler.
Can you wait for her to finish asking the question before you start responding? Go
Okay,
ahead.
Judge, I'll ask it a little differently. At that point, you guys didn't know who, if anyone, could have been targeting the two families. Is that correct?
Sure.
Thank you. I have nothing further.
You can step down. Defense, call the next witness.
The defense will call Melissa here.
the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Once you're seated and comfortable, can you state your full name for the record and spell your last name, please?
Marissa Caneiro, Caneiro.
Okay. Ms. Caneiro, I just asked you to speak up. You probably heard me say that a couple times. Just speak up so juror number 15 and 16 can hear you. Go ahead, counsel.
Good morning, Melissa.
Good afternoon, Marissa.
Can you just introduce yourself briefly to the jury?
I'm Marissa, and I'm Paul's youngest daughter.
And we heard a lot yesterday from your sister Katie about what transpired on November 20th of 2018. So I just want to focus you in on one specific thing that happened. At a certain point, were you at the police station with your family?
Yes.
And during that time, were you taken downstairs to a conference room?
Yes.
And while you were in that conference room with your dad, did you learn any information about what was happening with your family?
When we were alone, me and him.
Yeah, here, I'll back up. At some point, are you in the conference room with your entire family?
Yes.
Okay. And thereafter, were certain members of your family taken out, and were you left alone with your dad in the conference room?
Yes. My mom and sister were taken out of the room, and then it was just me and my dad in there.
Okay. And when it was just you and your dad, was there a point in time where you learned information about your family?
Yes. A police officer came in, and he told me and my dad that...
You're saying, I'm sorry.
Just say.
Did you learn what happened, just without saying what was said, did you learn what had happened with your Uncle Keith and Jennifer and their family?
Yes.
And did you learn that they were deceased?
Yes.
Okay. And can you just describe that moment that you learned that and what your reaction was and what your dad's reaction was?
Relevance.
You can answer as it relates to your dad.
When they told us that everyone died, my dad was really upset and crying. He fell to the floor, and I was sitting across from him at that point. So I got up, and I was on the floor with him, just holding him. He was crying a lot, and my shoulder was wet. And then eventually they told me I had to leave the room as well. So I don't know what else happened.
When you were in the room with your dad and he was upset and crying on your shoulder, did you say he fell?
Yeah, he was sitting on the chair, and then he fell to his knees. So I went over there and I was just holding him up.
And about how long were you on the ground with your dad before you were taken out of the room during this time?
Maybe 3 to 5 minutes.
That's all I have.
Ross?
Just a quick question. When you were in the police department, ma'am, you were allowed to keep your cell phone on you, right?
Yes.
And all of your family members were allowed to keep their cell phones. Is that correct?
Yes.
Okay. And then eventually you ended up giving a statement. Is that right?
Yes.
Okay, and then you left that night, correct?
Mm-hmm. Yes.
I have nothing further, Judge.
Let me step down.
Can I ask a follow-up?
Sure.
Did you have cell phone service when you were?
No.
Nothing, Judge.
You can step down. Thank you. Call the next witness.
Can we approach?
Okay. Any research? All right, I'll be back home in 5 minutes.
Ms. Vassalone, what is your pleasure?
Judge, at this time, the defense can rest in front of you once the jury's brought out.
Okay. Mr. Caneiro, can you stand up for me? Okay. Mr. Caneiro, there's a charge, a model charge that can be given, but it's truly your decision on whether that I give this or not. It's titled Defendant's Election Not to Testify. It says, as you know, defendant elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that the defendant did not testify. That fact should not enter into your deliberations or discussions in any manner at any time. Defendant is entitled to have the jury consider all evidence presented at trial. He is presumed innocent, whether or not he chooses to testify. Have you had the opportunity to speak to your attorney as it relates to this charge?
I have.
Okay. And what is your position? Do you want it read or not read?
Read to the jury.
You want it read?
Yes, please.
Okay. And that you've had enough time to speak to your attorney about that?
Yes,
All right. And after full consultation, you want me to read this charge?
please.
I will read it. Okay, thank you. Thank you, sir. All right, ladies and gentlemen, so what our plan would be, is there going to be any rebuttal?
No, Judge.
Okay, so with that being said, what I will do is I'll bring the jury back out. The defense can rest. The state will then indicate that there will be no rebuttal. At that point in time, we have already started with the moving of evidence. We'll continue on in that process. We'll go over the jury charge for the last time, and then we'll be ready for summations. Not today. Can we bring the jurors out, please?
1 second.
Yes, please, if you don't mind. Forgot to stand up.
There you go. I got you.
Everybody can be seated. Thank you. Okay. At this point in time, what is the state's preference, or the defense's preference with moving forward? Any other witnesses?
No further witnesses, Judge. We rest at this point in time.
All right, so the defense rests. Will there be any rebuttal from the state?
Judge, there will not be any rebuttal.
Okay. So, ladies and gentlemen, here's where we are. We're at a time where all the testimony has been concluded. One area that still is outstanding that's going to be done now outside of your presence, you will not have to sit here for it, but I decide, remember all the exhibits that you've heard about through the course of the trial? The court makes a decision on which actual exhibits you have in the jury deliberation room at the time that you start your deliberations. While you may not have every single exhibit that was mentioned, you would be able to consider the testimony of any and all exhibits. It will only be the exhibits that I give you or the ones that you're allowed to physically have in the jury room. So if you're one of the 12 deliberating jurors and you say, Judge forgot to give me exhibit number whatever,
I didn't forget. I promise you that. You're going to get what you're going to be allowed to have, but you can always remember the testimony. That's why there's 12 of you that will decide this case, and you can remember whatever you want to remember. So that's number one. Number two, if you recall, what I've said is that at the end of the case, at the end of the summations, I give you the law that you will have to apply to the facts as you find the facts in this particular case. I go over that law with the attorneys on several occasions before it's ever read to you. We've done that a few times. I'm going to do that for the final time this afternoon to make sure that that's also accomplished. So while I'm letting you go, and I know today was not the best for time-wise, I hope that you understand that our plan is we're going to finish that up tonight. Summations will be tomorrow morning. You'll be here tomorrow morning at normal time, which will be 8 o'clock. We'll start at 8:30. Summations will start in reverse order. We start with the defense's summation, then we'll have the state's summation, and then we'll move into the actual charge. It is after that, then we get into the deliberations, and we'll pick, if everybody remembers, then we get to see how we pick alternates in this Monmouth County. Pretty high tech. It's very exciting. I can't wait to show it to you. So with that being said, though, that you're done for tonight, you don't discuss this case. Now, just because we're at a point where we're done with all the testimony, do not discuss this case. There's no greater time than right now than a need for you to listen, not to discuss this case at all. You haven't heard the summations. You haven't heard my charge. Only deliberation is done in that jury room with the door shut, and that's for you and you alone when you decide to start your deliberations. So with that being said, don't discuss this case. Don't do any research. I hope you have an excellent night. I'll see you tomorrow morning. Please be safe. Thank you so much. Just give me 1 second, please. So, we're going to go back to the exhibits. We spent a good amount of time on Friday afternoon going through all of the exhibits. Let's talk about, have we figured out the photo book for S1 and taking out the photos?
Yes, we were just, the only one was A, I believe, that we hadn't done, just to make sure that we didn't use anything else, but that everything else is complete, and Ms. Schmidt is actually just finishing subsection A.
Okay. All right. So the defense, tonight, you can take a look at it, or before we leave today, because it's only A, it's not as many photos as some of the other sections. But the plan is to take out the photos that were not identified. Is that correct?
That is correct, Judge, and that's what we've done thus far with all the other portions.
Okay. I'll give the defense time to take a look at the book, to go over it, make sure that they're in agreement with the photos. If there's any photo
that is still at issue, that on whether it was identified or not, I have them all marked in my photo book also, and I'll give everybody, I would address the issue at that point in time.
Which I did have an opportunity to review, I guess, most of the sections, and as a result, I had just some objections to a few of the photos.
Okay, great.
I don't know if the court wants me to discuss.
Yeah, that'd be
those.
great. Thank you. So tell me, let's start with B in the photo book then.
Judge, I can just stick to the only objections I have are with like the autopsy photos,
Okay.
and the only thing. Photo, for example, photo number 7 is, I believe, a photo of Keith's hand and stomach area, and then they have on top, like after that, 7.1 with like some markings. It's really just a circle, I believe, or something to that effect, and so forth and so on. So they have 13, which is Keith Canero's head, and it displays 5 gunshot wounds, and they have 13.1, which has certain gunshot wounds, I think, circled, and then they have 13.2, which has more gunshot wounds circled, or something to that effect. I don't have it in front of me, I'm just working off of my notes, but they do that for photo number 14, and then they have 14.1 and 14.2, photo number 15, and then they have 15.1, and they have photo number 16, and they have 16.1 and 16.2. Those are 3 gunshots, including like a gash-shaped gunshot wound on the top of the head. So there's 3 of the same photo. It's just that there's like a circle around something. My position, Judge, well, I'll just keep going. Then there's 17, and then there's 17.1, and then there's 23, and then 23.1, 26, and 26.1.
17 is just the bullet fragments from the brain.
Yes, there's, it's a projectile from the brain, but there's, I believe, like there's like blood and brain matter.
Okay.
And then 25 is Sophia, and 25.1. So my position, Judge, would just be that it's essentially cumulative to have the same, and prejudicial, to have the same autopsy photo numerous times. You know, if the state wanted to use the ones with the markings because they're probative in some way, obviously they can do that, but my position would be that the original should be taken out, since the photo with the marking is obviously, it shows the original plus the marking, or alternatively that they just keep the original and go off of the testimony. Everything, all of the autopsy photos that have markings on them are simply like one wound being circled, I think, with like a pink circle. There's nothing initialed or drawn or explained. I don't, the jurors can see that it's a bullet wound for themselves, and I just think to have repeated photos of the same thing is,
So you're fine with the .1s or .2s, you're just not, you don't want the duplication of the regular photo with nothing on it and then the circles. Is that what you're saying?
that is what I'm saying. And
Okay.
if there's multiple points, if there's like a 16.1 and 16.2, and it's because 16.1 has like one circle and then 16.2 has 2 circles, I think that just whatever the final product is of that photo is appropriate, would be my position.
Okay. State's position as it relates to that, if you have the marked up photograph, do you have a position whether it's necessary to have the photos that are not marked up also? And if you do, tell me why.
I'm just trying to evaluate the printer quality, Judge. I mean,
Sure,
obviously,
no problem.
You know, there are some differences in the quality of the photos, but, you know, I do see, I certainly would not want to take out anything that was marked up by Dr. Zhang in this regard.
Well, that's why I'm really asking you, do you need the regular photo, considering that I would allow the .1 and .2, or whatever it is, if they're circled in the testimony? Or
Judge, I will defer to the court in that respect, but I do think that we obviously went through a process, a significant process of narrowing down and paring down autopsy photos.
Yeah.
And ultimately, like, I showed like one picture of Sophia Caneiro, which was a horrible picture, and I left it up for like 0.3 seconds. If they feel the need to look at all the photos, that's part of their determination. I would really ultimately say that I think the photos should stay in as is.
Okay. So 7, I should start with number 7. And 7 had, slide 7, that it had it's not on the list here. Is it a 0.1 and is it more than a 0.1? So slide 7 shows Keith Caneiro's hand. It also shows part of his stomach area with what was identified as a gunshot wound that went through his hand into his stomach area. Actually, through his stomach area into his hand.
It's actually through his lower back, through his stomach, and then
Right,
through his
hand and outside.
2 entries, 2 exits.
Yeah. As it relates to that particular photo, I'm going to allow 7 and 7.1 due to the fact that that injury in and of itself, the jurors may not remember, and I sat through the testimony also and listened intently of the track wound of that injury. So as it relates to 7 and 7.1, I'll allow it. I find the probative value outweighs any prejudicial effect. There's no significant showing of the body here. There's nothing that leads this court to believe that the jurors would be inflamed by this particular photo, and I'm going to allow both photos 7 and 7.1. The next photo I believe that was mentioned was 13. So 13 had, I was testified to by Dr. Zhang, these 4 holes in Keith's face underneath his right ear is a bullet going in, comes out, goes back in and out. And 13, can I see 13.1 and 13.2, please?
Yes, sir, Judge.
If you don't mind, that would make my life easier. Thank you, sir. As it relates to 13, 13.1, and 13.2, the court's going to allow 13.1 and 13.2. That provides a framework for the testimony from Dr. Zhang as to the directionality of the gunshot and how he found it and how it went through the neck and then through the face of Keith Caneiro. And it also talks about, it reminds the jury of the third hole right by the ear as it relates to what he found at that location. So I'm going to allow 13.1 and 13.2. I'm going to exclude 13 as cumulative. I don't think it's necessary for that shot. I feel that that photo doesn't provide any further evidential value for the jurors to make the determination as to that track wound of the bullet. So therefore, I'm going to exclude 13. Again, 13.1 and 13.2 are in evidence. As it relates As it relates to 14, there's a 14.1 and 14.2 for the same reasons. I'm going to allow 14.1 and 14.2, which shows Dr. Zhang testifying about where the entrance wound and how it goes in from the side of his head through the upper part of his head. The actual gunshot wound and the directionality of it from 14.1 to 14.2, the circles there. I'm going to allow 14.1 and 14.2, and I'm going to exclude 14 as cumulative. Same for 15.1. Allow 15.1. And for the same reason, 15 will be cumulative. But I find that 15.1 has a probative value to explain where it was documented of where the entrance wound was located and circled. I make the same finding for 16. There's a 16.1 and 16.2. I find 16.1 and 16.2 to be evidential. It shows the wound. It orients the jury as to the testimony as it relates to those specific injuries. And for that reason, I will include 16.1, 16.2, and I will exclude 16 as cumulative. For 17, which includes the projectile from the brain and how it was impacted as it went through Keith's skull, 17.1 circles the projectiles. However, in the circling of the projectiles, it kind of goes through the projectile and in some ways obscures the actual photo. 17 is a clearer shot of these items, so therefore I don't find them to be cumulative. I find them to each have their own evidential value, and for that reason I'm going to include slide 17 and 17.1. They're both included in evidence. Okay. Ms. Massalone, was that the only area of the photo book, or was there some other area that we needed to discuss? Mr. Decker, I'm sorry, I stole your book.
That's okay.
Thank you, sir.
Judge, we have no other issue. There was one other photo that we discussed with the state. They're not admitting it, and that's it.
Okay. So the only one that we have left then to discuss at some point is A, after you receive it, correct?
I just reviewed it, Judge. I have no objection.
Okay, so A, as noted, is in. So the final photo book, Mr. Decker, will be where for when summations start tomorrow? Is that the book that you have in front of you?
There's two books.
There's two books. Okay. So I just want to make sure that final book is in a spot everyone is agreement with it. I don't want it to get lost for any reason. I don't mean that in a negative way. I'm not saying you guys would do that. It's just making sure that we don't want anything going into the jury room except for exactly what we all agree to. Okay? All right, thank you for that.
Judge, I did previously show the state the photos that we were likely intending to admit. They indicated they didn't have an objection, but I didn't have an opportunity to choose our point ones that we were going to show. So I have them now. It's not too many. I can hand them to the state if they want to take a quick look.
Okay.
See if there's anything.
Yeah, we'll have time for that. All right, so I'm going to move things along. I'm going to remind us of what we already have in evidence, and then we can go over, Ms. Wallace, if there's items that I may blow past that we need to talk about, just stop me, okay?
Okay.
All right, so S2 is in evidence. S7 through S12, including the point 1, point 2, point 3, point 4, point 5, and number 12, all in evidence. S17 through S19 in evidence, including proposals A, B, and C. S26 in evidence. S28 in evidence. S29 in evidence, including point 1 through point 10. S30.
I'm sorry, I think the points were in evidence for that.
Oh yeah, you're right, and not the main document. You're right. You're right. Sorry about that. So it's just 29.1 through 29.10 are in evidence, not the overall statements. I apologize. Same with 30. It's just points 1 through 19 that will be in evidence, not the entire statement. Next were the area of S33 through S38. We discussed them. I think we said that 33.1, 34.1, 35.1 were in evidence. However, is there anything else from 33 through 38 that we needed to have a discussion about, or that was being moved or not moved?
No, Judge, we looked at them. We're good with where we left off.
Okay. So it's just 33.1, 34.1, and 35.1. Otherwise, not the entire document. And 36, 37, 38, there was no point ones on those, so they are not being moved. S40, we're moving in A and B. But that's the only areas. Okay, we had we were going to revisit S42 and 43. Ms. Wallace, where are we with those?
We just spoke to Mr. Murray. We are good with S42 being moved in, but not S43.
Okay. So you're not attempting to move in 43, correct?
That's correct, Judge.
All right. And you're good with that, Mr. Murray?
Yeah, I took another look at 42, and I think that the large bulk of it was testified to already, so we don't have an issue with that.
Okay, great. Thank you. S44 through S53, all in evidence. Next one is S61, A and B are in evidence. The next were the S60 through 65 that we reserved on. Did we come to an agreement on that?
Judge, the state's position is still that those should be moved in. I would note that we did mark, or we did look at, and we put up the index on that, which is what Detective Niglorisi actually drew on at one point. And that index had the dates of 4/13, 9/13, 9/17, and then 11/5. So I understand, obviously, that's the state's position.
Okay. And the defense's position, go ahead. I know you have objected to it because you said it was confusing, the way that you have to read it. It was a little difficult. But was there anything else that you wanted to add to that?
Judge, if the court is inclined to allow it, then I would just ask that they be like page numbered, so that at least if they do get disorganized, there's some sort of mechanism to put them back in order. Perhaps they can just number them.
That's fair. That's fair. I'm going to allow them in, and I'm going to ask for them to have page numbers. I agree that the page numbers would be helpful. I do find them to be relevant under the circumstances they were testified to. And I do find that under the circumstances, the jurors should have them. But can we have Ms. Wallace have somebody do some page markings on these? I know it's going to be a lot to do tonight.
Yes, we could probably put them in binders too. Just we can even print the index. I don't know if that's something that would probably be helpful, having the index on it as well.
Fine too. Just as long let the defense see that at some point.
Okay. I was just going to add, if they're going to put it in binders, that makes sense, maybe like a cover page with the date to organize them by date.
Yeah, that's fine.
Again, our initial position is an objection, but that's
Of course.
our position.
Yep, your objection is definitely noted from before. It's noted again here today, but I'm going to allow it in. However, I do agree with you that page numbers are helpful. Okay. S66, A and B both in. S69 and 70 both in. Next is S74. All parts of S74, A, B, C, D, and D1, all in. S76, including clips A through D, all in evidence. S78 in evidence. S93 in evidence. S94 in evidence. S96, and I believe it's just B in evidence because the first 911 call was not something that was a hang-up or something.
That's correct, Judge.
Okay. So it's just B. S99 in evidence. 101 and 102 in evidence. S155 through 166, all in evidence. S168 through 177 in evidence. We reserved on 178, which was the padlock Pelican Storm case 2050 with a knife flashlight. If you guys had the opportunity to discuss that again, has that been worked out or no?
I don't think it's been worked out, Judge. It's a locked case which was opened for the purposes of removing the gun and sending it for testing to the state police. We submit that obviously there was a lot of weapons that we didn't utilize in front of this jury, but that is one of the handguns that was tested, and that was the way it was found.
Okay. All right. Ms. Mastellone, I know you objected to it, but I'll allow you to, if you want to object any further now, or if there's anything else you want to add.
Nothing to add, Judge, just an objection.
Okay. I find under the circumstances that the jury, because the jury's not going to physically have these items, that it's more of the testimony anyway. However, I do find under these circumstances that not all items were sent to the state police lab. This one was. If the jurors for some reason had some reason to want to see it, it will be in evidence for them to be able to see. I don't know if they even will, but I do find that the probative value outweighs any prejudice to the defendant. Again, for the reasons that these items, as it relates to all of these guns that were located at 27 Tilton, they're not all going to be physically in evidence, so I have no issue with it. All right, S179, 180, 181 are in evidence. S183 through 196, all in evidence. S214 in evidence. S222 is as a continuation of the same argument from before, dealing with this small plastic bin with 6 magazines and 11 finished lowers from basement of 27 Tilton. Ms. Wallace or Mr. Decker? Anything else you want to add to that? Or you-
Judge.
Ms. Maslow? I know you objected to it before. I'm just giving you the opportunity if you wanted to say anything else.
Judge, I'm just gonna other than the text messages, when we're dealing with the ballistics, since that was Mr. Murray's witness, I'll let him.
All right. So 222, we don't have an objection to.
Okay. That's an evidence. All right. As 230,
What reserve on 225, or was 225 previously ruled in evidence? Over objection.
I have it crossed off that I was not allowing it in evidence, 225 or 226.
Okay.
The arguments can be made, but I said no to the actual items going in. 230, 231, A through E, and then 233 up to 242, all in evidence. 256, A and B in evidence. 261, 261.1, 262, 62.1, 263, and all of its subparts A through M, and there was a lot of point ones added. They're all in evidence. 264 in evidence. Then 270, 271, to include A, B, C, D, E, F, and then 271 A1 and 271 C1, all in evidence. 272 in evidence, 273 and 274 in evidence. 285 and its subparts A and B, and point 1 and point 2 in evidence. 299 through 338, all in evidence. 347 in evidence. 375 in evidence. 391 in evidence. 392A, E, and H, all in evidence. 405 in evidence. 407 in evidence. 418 and 419 in evidence. 437 in evidence. 467 in evidence. 474 in evidence. Then we said we were going to hold off on 476 through 480. I don't know if there was any more consideration as it relates to the DNA from the state. I know that the defense is going to be asking for certain items. I'm not saying I'm going to put them in. I'm just saying that they wanted to move certain items of their evidence from their experts. So I'm asking you what your intention is with these items.
Just trying to recall what they wanted to put in from their expert.
Mr. Murray, that was your witness as it relates to Dr. Reich.
Well, Judge, there was also the exhibits that were published during Daniel Reed's testimony. I think we didn't really get to those last week when we talked about.
Okay. Which ones were you looking at there?
So Mr. Decker will be able to argue, or Ms. Wallace, whomever.
That was Miss Stallone's witness. On cross, she can correct me if I'm wrong, but I would imagine it was 140 through 143.
They were the,
S 140 to 143 or D?
D 140 to 143.
Okay.
they were the, and the state, when we initially showed it to them, they didn't have an objection. There was nothing additional, I think, that we had, or from his power.
One is the one you wrote on. I think that's 140 or 141, right?
Yes, 140 is Bodie's, chart, likelihood ratio chart that I wrote on.
Yeah.
141 is the allele chart that was highlighted. And then we had the two deconvolution reports, which really there was, not the whole thing was referenced, but portions of it. So that's what we were initially asking to be entered into evidence. I don't recall what the state was asking for. I think we wanted an opportunity to confer with them. We just haven't spoken about that yet.
I mean, I'm just struggling with the idea that, I mean, obviously, we want the Bodie results in on that chart, but there's other results that are in reports, and then we just have certain documents, just because they're highlighted, doesn't make them any more evidential. I mean, I think it's
Well,
kind
there's
of,
writing on 140 that's testimonial, and then there was writing on 140.1, which Ms. Wallace got back up, used the same document, and then we pointed that out. And we made that a different exhibit. I have no problem with that timeline going in for both of you, both sides. I think it's fair. It's testimonial on the document. Ms. Wallace, I forget what you marked when you got up and you asked for it, and then we.
On the DNA report, Judge? Or
On the Bodie report. And then there was the back of a notepad that was written on, if you guys remember, it was Miss Mastallone's notepad.
Because that was the timeline. That was through Detective.
That's a different timeline?
Yes.
I'm sorry.
it's okay.
Mr. Murray's notepad.
Technically, it's a .1 exhibit because we didn't preserve the notepad as an independent document. So
Valid point.
Fortunately.
Right. Did you, why, you don't want all your notes to be put in evidence?
I prefer not.
All right. All right, so your position is what as it relates to the Bodie chart?
The Bodie chart, I'm 100% comfortable with that going in.
All right, so
Obviously,
that's 2.6. That's D140 going in.
and D4, is it 141? I have no issue with the allele chart table going in.
I don't see the value of the deconvolution report because there's areas of the report that was not testified to. However, I mean, the exhibits were shown on the screen. I think it's fair comment by both sides. Both sides used the deconvolution reports, less used by the state, more used by the defense. But I have no problem with those being discussed in detail if you want to discuss them. It's just that the entire report, and there's a lot of areas of the report that was not discussed, and I don't want them getting confused as to what each thing means or and trying to figure it out. So,
I agree, Judge. I don't necessarily need the entire report in, but perhaps just the portions that were published.
then you're going to have to redact the front page because there's items on the front page that some were testified to, some were not, as the Gelman-Rubin and the fallout ratio or the burnout ratio. Some of the stuff wasn't even touched.
I mean, Judge, if we had a little bit more time to think about it, then, we could perhaps come up with a solution. I'm not sure in this moment. I mean, again, things that were published, I think, the jury jury should have access to it. I mean, maybe we could agree that they don't have it back there in the jury room, but if they wanted to look at it, we could allow them to see portions if they had a request.
Can I have D 142, 143, please? Thank you. You were standing up, Mr. Decker. I don't know if you want to say something.
I guess, Judge, I'm just trying to figure out, I just don't want to confuse the jury on, like, they're not actually getting the DNA conclusions in some respects, like the state police, the actual expert report from the analyst, but then they're getting, like, deconvolution reports that are part of the analysis leading to a conclusion, but they're just not getting the conclusion. Like, just because an exhibit was shown or published, I think the way I look at it is if I would have shown Chris Clayton his report and said, let me publish this and have him underline his conclusion, I don't think it would make the report any more admissible just because he, like, pointed that out. It would be I think it would be kind of like a great way to backdoor every expert report. We're all certainly going to talk about the DNA conclusions in summation and ballistics and stuff like that. But if we're going with, like, the expert reports aren't coming in, I think that's kind of where we're at.
I hear you. Go ahead, Ms. Massalone.
Again, Judge, I really haven't had time to think about it, but maybe if just in the event that they ask for a readback, it could be made available to them. If it was something that if it was a specific area of testimony that they were interested in.
Yeah, I'm not going to allow the physical documents in because a lot of it was not testified to. Anybody can comment on it. If it becomes an issue, excuse me, if it becomes an issue on a readback, we can discuss it at that point. But I'm not going to allow it in for now for the same reasons that I didn't allow in other reports from either side, just like I wouldn't allow Reich's report in. I wouldn't allow some of these deconvolution reports because there's so much information on here. I find that under 403 it would be confusing to the jury to fully understand all of it, and I would not want them to go back and trying to do become their own expert in DNA analysis. So I'm not going to allow 142 and 143, but again, if something comes up during a readback, then we can discuss it then.
Should I just ask one question?
Sure, sure.
We didn't get to, I understand the court's ruling on Dr. Reich's report. There was also the PowerPoint presentation.
Yeah, let's take them one at a time. I'll get to you. I didn't mean to jump ahead. I was just using that as an example that throughout all of the state's exhibits, I didn't allow any investigation reports or any other person's reports. I was only drawing the same analysis, but I didn't get to that yet. I didn't know you were even trying to move it. So let's wait until we get there, if you don't mind.
Thank you.
So can we go back to the state so just the record remains clear? Considering that the court is not allowing deconvolution reports, is there any request for 476, 477, 478, and 479, and 480 for that example?
No, Judge, under the same ruling, I would suggest that would be consistent.
All right, so no to all of those. And again, it's free reign to argue whatever you need. And then
I think the only other one was the photograph of the defendant and his daughter, 501. Is that being moved or is that not being moved? I don't recall.
No, Judge, I don't think that foundation was properly accepted by the court.
And anything that happened today in any of the exhibits that occurred, or do you want to wait to hear what the defense is going to request before you get into that? It was 502 through 505, I would assume, because the last one I had was 501.
Should we be moving, seeking to move 504 and 505?
This is 502 and 503. That's just the DNA's.
Okay, thank you. Yeah, so the state would be seeking to move 504 and 505.
504 and 505 deal with the cell phone
Yes, that
and the
is,
extraction?
yes, that's correct. 504 is the first page of that. And then 505 is another page that was shown.
Okay, so my question to you is that the state, and again, I understand how we got to where we are today, but we don't need to go back to that from this morning. But if it was an agreement not to put in the phone, the screenshot of the phone where it says it's red, how do I put in 504 and 505 after the testimony is already out there, but not the reports?
Yes, I didn't realize there was an agreement not to put, I don't think I understood that, not to move in the screenshot.
Well, it wasn't, and I know we discussed it, and I believe what Ms. Massalone said, and I will not put words in her mouth, she can say whatever she remembers, is that it was my understanding that she was not intending on doing it. However, if something came up, she would let us know at sidebar that there was some questions that she wanted to ask, which she did not do. So with that being said, that is the reason why that I'm just wondering, considering we did not put any report in about this, if that's your plan. If you want to put it in, then I'll hear from the defense.
I mean, I think the state, I think the state would be seeking to move that in. There was testimony about the facts of the text message itself. And this was shown to the witness. We marked it, we showed it to her. So I think for purposes of completeness, the state would be seeking to move these two documents in.
Okay. Let me hear from the defense as it relates to 504 and 505.
Judge, the court is correct. I mean, the defense was never intending to use the screenshot, but rather to simply elicit her testimony, which reflected her recollection of what occurred. I did not question her on the screenshot, and I sort of found out in live time that the prosecutors were going to question her about the group chat, which they did, and she wasn't able to, I guess the foundation was not really laid as far as the admissibility because she didn't recognize it. She's never seen it before. The prosecutor asked her, does this appear to be a group chat? And she says no. And so my position would be that either none of it comes in, which that was what I assumed was the agreement as well, or that in fairness they should all go in because, again, it goes to her credibility and completeness. She's not lying when she says that it is a text message between her and her aunt that says red. And we know that she's not lying because she testified to it under oath. We have a screenshot of it, and the prosecutors themselves saw the screenshot. They saw her phone earlier today where she showed it to them. If they want to suggest that it's a group chat as opposed to a single screenshot, if they want to show that that's what the extraction shows, then fine. But then we should also be able to show what this witness was looking at, her own phone and the screenshot. So I think as a matter of completeness, it should be nothing. which was originally what we assumed, and I didn't question her about it, or it should be all 3 items.
Anything else?
No, Judge, I'll leave it in the court's discretion.
I think that the testimony was clear. I'm not going to allow the document in because I'm not allowing the screenshot in under these circumstances, but the testimony is out there. The document can be referred to as part of your summation as to to remind them of the testimony. I'm not sure if I actually agree with the defense that because she testified under oath that she was telling the truth. I don't know if she is or she's not. All I know is what the extractions say. She saw extractions from the defense. She recognized it. She saw an extraction from the state. She doesn't recognize it. All I know is that I'm not going to allow them in, but I will allow the state to comment on those items 504 and 505. So they will not be in evidence. Now let's go to the D exhibits.
Judge, I do have a concern about, I don't know what the state's comments would be as far as that exhibit, because, I mean, it would have to be consistent with the testimony, otherwise the state is essentially testifying. So I'm not sure what that means, that the state can comment on it. I mean, Again, I think that the defense and the state could meet and confer, and we could come to an agreement if we had a moment. But, obviously it wouldn't be appropriate for the state to be testifying to things that weren't testified to by this witness in their closing. As to the witness's credibility, Judge, again, that the state saw the phone, so I think that speaks for itself.
I didn't see the phone. Is that what you just said? I didn't see the phone. I have no idea what the phone shows and what it doesn't show, but it's not, I don't need to see it. It's the back and forth from you all. I've made my ruling as it relates to this. If the state and the defense want to confer as to what they're going to say, they're experienced prosecutors. I told them what they can and they can't say. It's within the testimony, and they know what she said and what she didn't say and how it was confronted and what the report, what questions were asked about the report. So I'm going to leave it at that. I'm not telling them what to say or what not to say. I'm not going to get in the middle of that because that's a different issue that I want to stay away from. So I'll leave it at that. All right, let's go to the defense exhibits. Mr. Murray, what I had, tell me if I'm wrong, your first exhibit that you moved in was D55.
That's right.
Okay. And then we had D64.
Yes.
D71 and D71.1.
Yes, those were published exhibits that we were moving.
Okay. 106.
106, yes.
Okay. 114.
Yes.
122.
Yes.
And then we're to what we discussed. Now, from your DNA, tell us which ones you're looking to move.
So I think there's an agreement on D140 and 141.
Okay.
Those were the marked up exhibits.
Is that correct, Ms. Wallace?
That's correct.
Okay.
The court's ruled on 142 and 143.
Right.
Then we had D150, which was published, which was the PowerPoint from Dr. Wright. Now, obviously, we're not looking to get in his report, but I think similar to the testimony of Detective Bassender, where, it's not the entirety of a record that's coming in, but a demonstrative chart that the jury is going to have available to them. I kind of see the PowerPoint to an extent the same way as those charts, so we're planning to offer that as evidence.
And that was, tell me the number, because your exhibit list stops at 144 for me.
Oh, so that's D150.
D150? state's position?
I mean, I just think it's another report that he drafted. I mean, we're leaving out a lot of DNA conclusions in this case. They're not getting them other than what they heard from the witness stand and what they're going to hear from me and or defense counsel tomorrow. So I just think it's kind of a little selective in the sense that they get some results and not the others.
Can I see the PowerPoint? Do you have a physical copy of that?
Summary of voluminous documents. Yeah, I mean, just for the record, the passenger charts were under Rule 1006, summary of voluminous documents. It's just to demonstrate the report.
Okay.
I do have it here, Judge. You know what? It might be in our, that room. Or it might be in our the other box that I brought this morning.
All right.
I have it here. I could either go get it now, or...
Why don't you put it on the screen? Oh, lost. All right. So this is page 1?
This is page 1.
All right, let's go to page 2. Page 3. Page 4.
Sorry.
Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Is this already in a clean copy?
It's already in a marked up copy, I believe, Judge.
Okay. This is 13?
This is 13.
Go ahead. Page 14. Page 15. Page 16. Page 17. Page 18.
It's 17 to 17.
Okay. Can you go back to page 5, I believe?
Yes. This is 5.
4. Let me just see. Three. And 2. Okay.
The court's position, as it relates to this document, this PowerPoint that was used by the defense expert in this case, which argues that, or that the defense's expert indicated that while some of the results were reliable, it also talks about how there were certain areas that potentially of another person being involved in this, or another person's profile was at the scene. The court finds, as it relates to third-party guilt, it's going to allow only certain portions of this to be allowed to be used. I'm going to allow slide 2. Go to slide 10 so everyone sees it. 10 will be allowed. 11, 12, which shows no unknown contributors out of fairness to the state, and then slide 13, where that shows an untouched Bodie report as to relates to not only the people that were excluded at locations, included at certain locations, but it also allows for the state, as it relates to the reliable results that were testified to, that he has a document that is not that has not been touched or altered in any way. Mr. Decker, I understand from your perspective that how do we have the defense to have certain charts to be available when the state does not. It's the court's position, right, wrong, or indifferent, but the court's position is that the defense's theory in this case deals with the issue of Corey Caneiro. The court finds that there is, whether there is a rational basis or not, is not for the court to decide, but that it was testified to. I'm going to allow it for this limited purpose, but I will also give you the ability to address that any way that you need to in your summation.
Thanks, Judge.
So it's 2, 10, 11, 12, and 13. Yeah, that, Mr. Murray?
Yes, so that's what can,
That's
in evidence.
2, 10, 11, 12, 13 in evidence. The rest of the slides are out.
Can the additional slides be commented on?
Yes.
Or part of a PowerPoint for closing?
Well, they're not in evidence.
Right.
So they can be discussed, but they're not in evidence. So they shouldn't be on the screen. But these, you have carte blanche to do whatever you want with.
Okay.
He's right here.
210, I'll show you.
Oh, not this.
Just for the 2.
This one?
Yes. 10, 11, 12, 13.
Can you just go back for a second? Sure.
This is it.
Oh, no, nice. Judge, can this one be admitted, which shows just the alleles that are unique?
I've already indicated my position as it relates to the items. I know you asked to put them all in. I'm not putting them all in. I find them to be cumulative. The one provides the coloring that shows the differences and also the shared alleles for each one. And so I'm allowing one of those documents, and that's the one that I'm allowing. Was, Mr. Murray, any other items between 145, I guess, and 150 or 151 beyond that I'm unaware of that you're attempting to move. And then I need an updated exhibit list from you by tomorrow morning, please.
So other than that, the slideshow, I don't think I can ask Ms. Mastalona. I don't think we're moving any of the things.
Just the photos.
Just the photos, yeah, but no documentary exhibits. So that would be it. Ending at 150.
Okay. All right. So now we can go to the defense photos. Have they been reviewed and agreed upon, or do we have certain ones that I need to address?
I don't think there's any objection to any of the objections.
Okay. We should, for the record, though, Mr. Murray, we have to put them on the record as to what numbers that they are.
I can do that now.
Yeah, whenever you're ready.
The one, I don't need to do the point exhibits, do I? I mean, I can.
No, if you're saying, is the agreement to include the point ones in what you're saying?
I looked at the point one exhibits a little while ago. There was one that was duplicative, which I told Ms. Mastalone, I believe she took it out, but otherwise they're fine.
Otherwise, you're good?
Yes.
Okay. So you don't, Mr. Murray, you don't have to say slide 1, 2, 3. If it's slide 1 through 30 that are in, then you can just say that. But you tell me. I don't know what you're going to say. So go ahead.
Okay, so I think what we have as of now, and the point ones are, I guess we'll do the point ones next, but
Okay.
this is, so we have, these are all D1 exhibits, so 1, then 6, 7, 9 through 12, 15 through 17, 21, 27 through 31, 34 through 38, 41, 43, 44 through 44 through 66. But we need to, there's no 1-50, but other than that, 44 through 66, but there's no
50.
There's no 50.
Okay.
71 through 75. 79 through 97.
I'm sorry, I'm just trying to keep up. I want to make sure we have everything. Did you say, where did you end up with the 60? 66?
66, yes.
Okay, and then we are at 71?
72, 73, 75,
Okay.
79.
Yes.
And then it's going to go
You had
80.
74 too, right?
Yeah, 74.
71 through 75, yeah. to include 74.
And then 79 is going to go all the way from 79 through 97. We have 100 and 101. We've got 116 through 127.
116 to 127?
Yeah.
Okay.
Yeah. There's no 122. Oh, I'm sorry. There is no 122 on our list.
No 122. Okay, no problem.
127 is our. Okay. And then after 127, we're going to go to 134, 136, 137, 141. Then we're going to go to 145 through 152. 166 through 169. 172, 73, and 74. Then jumping to 200 to 206. 208, 210, 211, 214, 216, 224, 226 through 231, 235, 36, and 37, 240 through 245, 251, 252, 254, 255, 256. Oh, this is, okay, so then 257 through 262, 264 through 2... I believe it's 264 through 287.
81, 82? 281, 282.
No, I'm sorry, I don't. I have 80 to 83. So, except for 81 and 82.
Okay.
291 through 293. We're going to 300, 301, 303, 304, 307 through 309, 311, 317, 317A, 318, 318A, 320, 321, 328 through 332, 400 through 403, and then we're at to end. We're going to have 420 through 430. Yeah, there is one issue is that I think 423 was that screenshot of my notepad. So I don't know if there is an actual 423 or if it's just a 423.1.
Oh, if you didn't mark the back of your notepad, it would just be the one,
I think it would just be the 1.1.
1.1.
Okay, so I'm going to take that out.
423.1.
423.1 would be 423 is not.
Okay.
Yeah,
You want to,
I'm not objecting, I just wanted to look at
no, I was talking to,
it. Sorry.
I agree, Ms. Wallace.
It's one. All of a sudden, it feels like.
You mind hitting the down arrow on that?
Doesn't work.
Just hit it anyway, just for fun. Try to turn it down a little bit for tomorrow. I agree.
I think it happened suddenly.
I don't think it works. Thank you, though. Pretty sure Damie's listening in the back. Damie, if you can ask Buildings and Grounds to come tomorrow and drop it 2 or 3 degrees, I'd appreciate it. Maybe 10. Any, you want to go through the point ones? I'm assuming you were done with the regulars.
I think that's it for regular votes.
Okay. So just give us the point one and we're done. And then we'll move on to the charge.
Judge, it is 1-1.1A, and then 100.2, 100.3, 101.2, 101.3, 101. There was actually, it looks like 101.2. Twice, so it's 101.2A or 101.4, whatever the court prefers, we can amend it.
Yeah, we'll amend it to 101.4, please.
And then 300.1. 301.1, 301.3, 301.4, 309.1, 317.1, 317.3, 317.4, 317.5, 301.2, 317.2, 307.1, 423.1,
423.1. Am I right? 423.1?
Yes, Judge.
All right. And again, no objection from the state, correct? All right. We've gone over the charge. Everyone has the final draft? It's been marked as C9. All the other drafts have been marked and will be preserved.
Okay, I know I've gone over it before. I'm just going to go over it. Stop me if anybody has any issues with any part of it. I want to go over it one last time. We start with the general information, then the nature of the indictment, presumption of innocence, burden of proof, reasonable doubt, function of the court, judge's questioning. I've included in the request about sidebar conferences. I added that into the area to the function of the court, the first two paragraphs. I'm not sure all of it was necessary. However, in abundance of caution, I put it in. Judge's questioning, function of the jury, direct and circumstantial evidence. We forgot to read the stipulation to the jurors, so that we need to do that. So tomorrow morning, just a reminder, and I need that stipulation, so if you guys want to write it up right now, so that thank you, we'll add that in to the stipulation part. Credibility of witnesses, identification. And right after identification, so I'm on page 9 and 55. Ready there? Okay, good. My thought would be, after identification, that's where I would put defendant's election not to testify before expert testimony. If you want it in a different spot, I can do that. I can wait until later, after the statement of the defendant or narration testimony or defendant's recorded phone conversations. That's up to you. But I thought after the identification, Mr. Caneiro is denying his guilt, and also denying that it was him, that the state has to prove beyond a reasonable doubt. I thought that was a safe place to put his election not to testify. Any objection to that, or if you want it in a different spot, just tell me where you want it, and that's where I'll put it.
Judge, we were thinking that perhaps it would be best to put immediately before you begin the 2C portion of the...
You want it there?
Yes.
Fine, that's where it goes then. So right after third-party guilt is what you're saying?
Right.
Okay. That's where I'll put defendant's election not to testify.
Or criminal... Yes. Right. You're right. That's right.
Okay. Okay. So we'll add that in, and we'll obviously clean up the charge to make sure it just says his in the spots that it should just say that, and to take out the footnote at the bottom on there. All right. So then we have identification, expert testimony. We have all of the experts on there. Prosecutors, can somebody remind me how to say Christopher, somebody's...
Thomas Wallace. Has this been Kovic?
Wait,
Koviak?
Simkoviak.
Simkoviak?
Is it?
Okay. All right. And Nazizan?
Yes.
Nazizan. All right. The rest of them. Was that our Cardenas?
Cardenas.
Cardenas. Okay. All right. Then there will be the statement of the defendant.
narration of, video narration testimony. Defendant's recorded phone conversations. Limiting instruction relates to the firearms. Witness pretrial prep. Third-party guilt. And defendant's election not to testify. Nobody has any issues with any of those areas, correct?
Not so far, Judge.
Okay. Mr. Murray? Or Ms. Vassalone? Okay. Then we go into the criminal code. We discussed, and I had indicated that the lesser included was the arson. I want to be clear that in this case, there's no lesser includeds to the murder. In this case, I've spoken to defense counsel in the past, and there was a discussion with Mr. Caneiro that there was no lesser includeds that were being requested. Is that correct?
That's correct.
Yeah, and for the record purposes, I would say there's nothing rationally based within this record to support anything other than whomever committed these offenses against the four victims. It's not an aggravated manslaughter. It's not a manslaughter. It would only fit the requirements of a murder. I don't find any evidence, any scintilla of evidence that there was any reckless behavior here. It was intentional, deliberate. So in that case, I wouldn't do it even over the defendant's objection. I agree with the defendant and defense that it does not exist. So after I read the murder charge, then I will explain murder by your own conduct, and then the verdict sheet instructions, as everyone will recall. I will give out the verdict sheet at that point. We'll need 16 verdict sheets for tomorrow. My law clerks who are seated to my left, they will give out, they'll have 2 packages of 8. They'll give one to the first row, one to the second row, and they can take one, pass it down. I'll then go over the instruction as it relates to each one, as it relates to the murder by your own conduct, and also the subsections afterwards of A, B, C, and D. For Keith, excuse me, B, C, and D for Keith, and then for Jesse and Sophia, there's also the additional question as it relates to age for both Jesse and Sophia. I'll ask them about that. Then I'll take the verdict sheets back so that they don't sit there and stare at it. And then we'll go to felony murder, count 5 and 6. Then aggravated arson in counts 7 and 8. After the aggravated arsons for counts 7 and 8, I'll then read the lesser included offense of arson, which again is the underlying charge for the felony murder. Then it is possession of a firearm for unlawful purpose, which is count 9. There's no count 10 now, so we'll go right to count 11. The verdict sheet that I have in front of me still includes a count 10, so count 10 needs to be taken out. Oh, no, I may have an old one sitting up here. So, yeah, so that shouldn't be in there. Oh, yeah. All right, this is an extra one. A lot of stuff going on up here. Let me just confirm. Yep. Then we get into the knife, which is count 11. And unlawful possession of the knife in count 12. Theft in count 13. As it was discussed with counsel, defense counsel had asked for the lesser included as it relates to the amount of theft that was taken. It's clear, though, in the charge on page 45, starting at the top, where it indicates that to find the defendant guilty of the offense, you must indicate whether you find the amount of money or value of the property involved. And it gives 4 different numbers: 75,000 or more, 5,000 but less than 75,000, between 200 and 500, and then less than 200. So they'll answer that question based upon whatever answer they give. That would be the degree of crime, if at all, if they find him guilty of anything as it relates to the theft. Then there's count 14, misapplication of entrusted property. Then hindering apprehension, counts 15 and 16. One deals with hindering the apprehension for the underlying crime of murder, and then hindering the apprehension of theft or the misapplication of entrusted property. Let's count 15 and 16. Then we get into I give an instruction about deliberations, how it must be a unanimous verdict. I then give the verdict sheet back out, and we'll go over each one of the questions, and I'll remind them of that. I'll explain to them how they have any questions. If they have any questions, how they go about asking them. After that is done, I'll ask for a sidebar for the attorneys to see if I've missed anything. I'll then have, I'm going to ask for, Anna, that you'll need to look at whichever one applies. We'll have to swear in my sheriff's officer who will be at the door for deliberations. I'm also going to swear in a sheriff's officer who will be at the back door, so that I can say for the record that this entire room is secure. I will swear them in, and then at that point in time, I will pick my 4 alternates. We need to get the wooden box, and if you can put the 16 numbers into that, we can take care of that. I will then do that. 12 will go in the box, and they'll start their deliberations. Please, at the end of summations, I'll give you guys a break, but when summations are over, I'd like to have all the evidence collected. I want to put the evidence into the jury room so that it'll be seated there waiting for them. If I don't think that we're going to finish tomorrow, where I've finished my charge, then we'll keep it out, and then we'll give it to them the next morning. Before deliberating, the 4 alternates will be brought back downstairs to 148. I may end up moving them because it's going to be difficult every time if we have a question or whatever it is. I got to bring them back upstairs. It's going to take a decent amount of time, so I may try to move them closer someplace. I got to figure that out. But as of right now, that's what they'll be in 148. Anybody have any objections, concerns, edits, issues that we need to discuss?
The state doesn't, Judge.
Okay. The defense?
Not at this time, Judge.
Okay. So with that being said, we will take the watermark off of the final charge. We will also mark, we will have to have marked for tomorrow 12 copies for all of the jurors so that they will be able to have them. I'll ask for us to make all 12 of them. We will also have to turn over a copy to each one of the attorneys, so if we can make at least 16 of them copies of it, that's what we're going to need. Verdict sheet will need 20 copies of the verdict sheet, so everyone has one so they can look at. Make sure with 21 to include Mr. Caneiro so he has his copy of the verdict sheet. All right. Anything anyone needs to discuss before we conclude for today and we start tomorrow morning?
Yeah, Judge, we have a very detailed stipulation on a fancy piece of paper here for the court. Ms. Wallace and I looked at it and showed it to Mr. Murray and Ms. Pastalone. I believe everyone's in agreement.
It says for the stipulation that would be added to under the stipulation section of the jury charge, it reads, Jesse Caneiro had an iPad. The parties agree that Jesse Caneiro's iPad was never seized or searched by police. Is that the agreement?
Yes, sir.
Is that the agreement, the defense?
Yes.
Okay. Do you want me to read that before we start summations, or do you want me to just do it as a part of the charge?
I would think part of the charge at this point would be sufficient.
That's fine.
Okay, we'll read it as part of the charge. If somebody, out of fairness, if somebody comments about that in their summation, I will not have a problem with that because I will address it within the actual formal charge. Let everyone know that. All right. Anything else that we need to discuss?
Can we just have one
Do we
moment?
have a minute to confirm with the state?
Sure.
Wheel is outside the courtroom. Right there. The wheel has been brought to the hallway.
Oh, nice. It's exciting. Do you guys know what you need to add and where?
We just need this stipulation.
What's birthday? That's hurtful.
It's on the record, so.
I'm not arguing that either.
Thank you all. Everybody have a good night. I'll see everybody tomorrow morning. Start at 8:30.
Sorry for that.